Good morning. I hope I'm audible to all of the participants. I, Mr. Pratik Salgar, welcome you all to the second day of two-day National Symposium on Law and Music, which is organized by Marathwada Mitra Mandal's Shankar Rao Chavan Law College in collaboration with the Lalit Kala Kendra, Savitribai Phule Pune University, Pune. I welcome all the participants, dignitaries, artists, researchers, academicians from music and law, both of the streams. So today we are going to start with the session by Sandhya Surendran. So I welcome Sandhya Surendran to this particular session and I will give the brief introduction about her and then the session will start. Basically, Sandhya Surendran, she is the lawyer with the 15 years experience and worked both in-house as a counsel with the at multinational technology media companies and also in the private practice as an associate at the country's leading law firm and independent practice with the special focus on Asia Pacific, UK, USA, and the common law jurisdictions. Then some of the great achievements are there with her record. So she was featured in the influential Woman in IP 2021 World IP Review. Then she was featured in the first ALB India Super 50 Lawyers list of 2020. She was featured in the top 500 powerful women in law India by World IP Forum in 2017. Also, some of the highlights as per her profile that she is the founder and the podcast host of Lex Talk Music, India's first music business podcast, focusing on industry insights and legal framework applicable to musicians and the business of the music in India. She is also the member of the India Music Allies, India's first collective dedicated to the empowerment of the musicians from the non-film music fraternity. She is featured author in the Indian Music Diaries for the legal insights on the music industry. She is also the member of a Women in Music Group India chapter. She is a vast working experience in the IP industry, and I'm very happy to welcome you, Sandhya Surendran, for today's session. And she will be guiding us on the session today, and the topic for her presentation is copyright and the royalties, bridging the gap between the industry practices and the law with special reference to Indian music industry. So I welcome again Sandhya Surendran ma'am, and I would like to request you to start with the session. Over to you.
Thank you so much, Pratik. I mean, you make me sound a lot more important than I actually am. But really happy to be here. And I think thank you to the college as well for having me as a panelist. I'm quite overwhelmed by the number of people. And I hope today's session, all of you find it interesting. And I think I've mentioned this to Pratik as well. I love participating in workshops because I realize I learn a lot more while I have these discussions, because there's a lot more to like gain from the questions that are thrown at me, because this is a very dynamic sector, and the topic itself is something which has constantly been evolving given the internet and given technology that has been developing. So, I mean, I won't waste too much time with like small talk, but I'm glad to see all of you and I hope all of you are safe. So I think to understand the aspects which form the gap between the industry practice and the laws which govern copyright in music, I think it's also crucial to kind of go through like the few basics to, understand how copyright works in music itself. And I know a lot of it might sound familiar, or there might be some terms which I might use which you might not have heard at all, because those are all industry usage. So I'd like to like walk you through all of that, so that it doesn't sound like Greek to you later, during the course of the next 1 hour. And I'm assuming everyone understands how a copyright works and what a copyright is. But how does it work in music? I think a lot of people don't understand the fact that there are three aspects to copyright in a song itself. So you have a copyright in the sound recording, you have a copyright in the composition, which is the melody, and you have a copyright in the lyrics. So together, all the three copyrights are separate individual copyrights in one piece of work. And I think it's also important to understand that there are certain references to master rights and publishing rights, which are important in these verticals. So an ownership in the sound recording and ownership in the copyright in the sound recording rather is referred to as ownership of master rights, and an ownership in your copyright in the composition or the lyrics is referred to as ownership of publishing rights. So somebody, typically in our industry, we have record labels that own the master rights, which is the rights in the sound recording, and you have publishers who own publishing rights, and you also do have composers and lyricists who continue to retain rights in publishing. Now I'll discuss why this is important, because this is where the industry practices kind of have a conflict with the laws. But again, I think before we go into that, I'll touch upon a few basics. um, I think all of you understand that a copyright is not just one single right, it's a bundle of rights. So it's like your right to reproduce a particular work, or your right to publish a particular work, or distribute it, or remake it, or recreate it. For that matter, even to translate a particular work, right? And when does this right come into existence? Do you need to register it for a copyright to be established? Under Indian law, thankfully, you don't have that. It's not mandatory that you need to register a copyright for you to establish a copyright, as long as it is an original expression of a work. Then you automatically establish a copyright the second you publish it. So it could be something as simple as, a tune that you have come up with on your own, you've composed and you've uploaded online. It could be any internet platform, maybe a SoundCloud or an Instagram. You create a copyright the second you publish it. And therefore, you don't really need to register a copyright to establish one, but a registration basically allows you to prima facie own the copyright. Like, you don't have to prove that you own the copyright. That is the impact of registering it. Like in India, you don't have any. There is no concept of statutory damages which exists in the American law, which essentially says that if there is someone, or if you have a claim against someone for infringing your copyright, the law allows, or the law basically mandates that the person who's infringing your copyright has to pay a certain X amount, which is calculated as per law, which we don't have in India. There's, I think, both aspects have pros and cons to it. And the benefit of having not having to like register is that, it's easier to, and you have, and since given the fact that technology has advanced so much, you have so many avenues to publish your original work. You do have a timestamp that is automatically created. It is a cheaper option to not have, and less hassle to just have it online and published publicly, as opposed to like registering every single time you have a new copyright in a work. Now I think when in the context of the symposium as well, the fact that we're talking about classical music and Indian folk or traditional music, there's a lot of gray when it comes to ownership of copyright in any of this. Primary reason being that most of Indian classical music or traditional or folk music is in public domain, which then means, does that mean that you can appropriate that work and call it your own? It's obviously, the answer is no. You there is always, there is the concept of moral rights, which is attached to the ownership of a copyright, is also very, very integral to the copyright. So moral right being your right to be acknowledged as the author or the composer or the performer, original performer of a particular track or a particular song, that kind of subsists even after the lifetime of an author. And you can't really, now in terms of, say, if I have to take the example of Carnatic classical music, like the holy trinity of Carnatic music, you have Tyagaraja, Muthuswami Dikshitar and Shama Sastri. The three of them collectively have formed the foundation of Carnatic classical music. So does that mean just because it has fallen into public domain, a lot of their work, in fact, even came into being prior to the Copyright Act was executed in the form it is today? So that doesn't really mean that you can claim any of their work as your own. But if you have an original expression of one of their works, and if you are recording it and putting it out there, then there is a separate copyright that is being created in it. So um, I know there's a lot of information that I might have probably shared right now in the last like 2 minutes. So I'm going to break it down further to just to kind of figure out where, when we're talking about public domain, to what extent can you protect a certain aspect of your work because it comes from a classical music background. And that I think is important to um, a lot of performers in the Indian music industry, because our most of us have a foundation or a backing in classical arts. So which means we have a lot of performers who have original unique renditions or expressions of maybe a Hindustani classical rag or a Carnatic kirti, which is not previously been sung in that particular format. So there is a uniqueness that is added, and which is what I meant by original expression of a work. So that original expression is something which is copyrightable. In that context, when we're talking about ownership of master rights and ownership of publishing rights, now the composition itself is something which is in public domain. So I can claim it as my own. But the uniqueness that I'm adding on top of it, that is my performance of that, is still unique. And that is where I have a copyright in. And that copyright is part of the neighboring rights in a copyright. So as a performer, I have a copyright on that original and unique performance of that existing composition, which is in public domain. Now, if I have gotten it recorded by a third party, I've hired someone to record it and upload it on my YouTube channel, then that recording is technically, I own that sound recording. That is my ownership in the master rights to that sound recording. That doesn't mean I own the underlying works, which is the composition. I own the performance and I own the sound recording. And I think this is where there was a huge conflict. I think in the last few years, you've probably seen it, especially with YouTube. We've had, content infringement claims which have come up saying that, a particular classical track is owned by a record label, which has obviously led people to like go up in arms, because these are all compositions which are centuries old. And, a label can't really claim copyright on the composition. I can understand if the recording itself has been used. But if the composition is being replicated and reproduced by somebody else, then technically there shouldn't be a claim by the person who owned the original master recording of the other song. And I think that's where we've seen like technology also has a lot to, there's a lot of ground to cover, and this is just in the case of YouTube. But if we look at distribution of music on other platforms like a Spotify or an Apple Music, I mean, obviously these infringement claims don't come up there, because this is common knowledge that all of this, like, traditional classical music, whether it's like Western or Indian, all of it falls in public domain, because they've gone way past the copyright term. The copyright term being 60 years from the date of publication for a copyright in a sound recording, and 60 years plus the lifetime of the author or composer for in terms of ownership in the composition or lyrics. So now, if I had to, coming back to an overall, like the how the industry itself works, why is it so? I think the uniqueness of the Indian industry stems from the fact that we have always been a very film industry driven economy. So the music industry and even the laws that have governed it have come out of basically being derived from the way the film industry has worked. So it's not that we don't have non-film music. We do have non-film music. We do have a big independent music community. And that is something which has probably been highlighted in the last few years, ever since the onset of online distribution has begun. And with the online distribution and with this development in how the music distribution has changed, I think industry stakeholders have also become more cognizant of the fact that we need to have changes in the law to match that development in technology. And this applies across the board. This applies to film music, this applies to classical and to non-film music. And I think to understand this further, I want to give you a better picture as to how royalties work and why that's important for an artist, whether you're a composer, whether you're a lyricist, or whether you're a performer, for you to understand the importance of royalties and what are the royalties that you've not really, thought of, but are actually being accumulated on the side. And um, so what is a royalty? Like I think we've heard this word being, um, thrown around quite a bit. But how does it work? And like I said, a copyright is a bundle of rights. And for each of those rights, that right to maybe distribute, the right to reproduce a particular track, or the right to publish a track, each of that, if to give it to somebody else, you need to provide them with a license to do so. And when you give them the license to do so, they are supposed to pay you something in return. And that is what a royalty is. So um, I'm just going to share my screen to show you a few slides which I've created. They're not like very pretty, but I hope they convey the message. Just a minute. Can all of you see this?
Yes, it's visible.
Okay, great. So like I mentioned, this is how a copyright in a song works. You have the song and split into three aspects. You have the sound recording, and the ownership of that is referred to as the master rights. Then you have the underlying works, which basically includes the melody and the lyrics. And then you have the ownership of that is referred to as the publishing rights. Now, the other aspect of this is the revenue streams that apply to each of these. Now, like I mentioned, the royalty is a license to use. So those royalties are applicable to each part of the song in different ways, right? You have performance royalties that stem from the performance of your composition or the performance of your sound recording or the performance of your performance itself. So who are these people? So the person who owns the publishing rights is entitled to performance royalties. The person who owns master rights is entitled to performance royalties. And the performer of a track is also entitled to performance royalties. Now, can you collect this on your own? The simple answer to that is, as per law, you can, but it is not feasible at all, which is why you need to register with a copyright society to have them collected on your behalf. Now, this is how intellectual property law has evolved over a period of time. The concept of copyright societies stems from the whole, collective management organization, like CMO, right? And it's economies of scale. It just makes more sense to have someone represent you, focused on only collecting royalties on your behalf. So if you're a member of that particular society, they will be able to collect royalties on your behalf from certain avenues who are bound to pay performance royalties. So where do you pay? Who are the people who would tend to pay performance royalties? Any place where your song is being played, that is pretty much what it is, or being performed. So even a concert where there is a singer who's coming to perform a few songs or perform a concert, the organizers of the concert are supposed to take or basically pay a certain royalty, provide a cue sheet to the copyright society, pay a certain royalty, and then continue with the concert. Now, whether and how this is being enforced is a different conversation altogether, but that is the flow of events. That's the workflow of how royalty collection goes when it comes to performance royalties. Now, mechanical royalties have been commonly misunderstood to apply to the ownership of master rights. But actually, historically speaking, mechanical royalties basically means the royalty paid for the mechanical reproduction of a composition. So back in the day when we had physical assets for distribution of music, like when you had a vinyl or a cassette, every time a new cassette was printed or a new vinyl was printed, the was pay the person a fee, and that was called a mechanical royalty. Today, things have evolved so much that in digital distribution era, its mechanical royalties have come down to every time a song is being reproduced, either through a stream or through a download, or if it's being played online, there are mechanical royalties that apply there as well. So how do people keep track of this? Now there are technologies and platforms and softwares which have come up over a period of time, which are now also being incorporated by corporate societies, so that they can keep track of the catalog of songs sung or composed or written by the members in their copyright society to collect on their behalf. And that's what mechanical royalties are. Now, streaming revenue is also a big gray area because every stream is split into two aspects. So every stream is a mechanical reproduction. So there is a mechanical license aspect over there. And every stream is also a performance, right? Like it is a play of a song. So the streaming revenue that comes is split into royalties applicable to mechanical royalties, which is to the owner of publishing rights. It is then divided into performance royalties, which would then be applicable to all these people, all these stakeholders who have a stake in performance royalties. And this is, I think, probably the most simple way I can explain it, because each aggregator, or basically each platform like a Spotify or an Apple Music or an Amazon Music, they have different formulas in which they calculate this split. So there is no one set formula which is issued across the world, which everybody follows, you know. And in the US, things are a little more evolved because now, finally, I think in 2020, they've had legislation which has come into effect, which allows the regulators, the government, to determine the rates at which these platforms need to pay rights holders. Now, it has a long way to go, but I'm hoping that we are heading in that direction because awareness has increased. People have understood that, streams are actually revenue sources. Now, the other factor over here to understand is that each stream is priced differently, even country wise, because this is based on the kind of subscription fees that you pay to access that platform. So, if I'm paying 199 rupees per month to access Spotify, I'm paying maybe 49 rupees to access Amazon Music. Obviously, the pricing between these platforms are also going to change based on that. If I'm paying 119 rupees in India for a Spotify premium um, membership, in America, someone who has to access a Spotify premium is paying maybe $30 a month, which is a significant difference. So the streams which come out of America are priced higher than the streams coming out of India, which is why the calculation kind of goes off. There is no way for them to actually have a uniform calculation because each country has different pricing, and these are all private companies. These are not government entities. So that is where the whole having the concept of having an equal playing ground is a little hard to achieve, because all this sector itself works in the private sector, and regulations have also not been uniform. The only thing that kind of unites all of this is the fact that copyright law is more or less the same across the world. So everybody knows that these are the royalties that I'm entitled to as an artist. And then, of course, sync license is something which you can reach out directly to the rights holder. There is no copyright society that technically handles it. So sync license is something that applies to, now, for example, if you have composed a song and if a production house of a movie wants to use that song in their film, they take a sync license from you. Now, this is a very simple arrangement. Say you are an independent artist, you have composed it, you have written the song, you have performed the song, and you have only uploaded the song and distributed it online. So you basically, that means you own all rights. So they just need to come to one person to get that sync license. But obviously, everything is not that easy. Most songs have multiple stakeholders. There are artists who perform through labels. So even so if I'm going to take uh, the example of Indian classical music, there might be popular artists, prestigious names who have been singing for decades and have a certain brand value which goes with them. They are signed up with a label, and the label will inevitably own all the rights, because in the case of a classical music rendition, the composition is not going to be owned by the performer. So what happens is that the label ends up owning the master rights. So even if there is a sync placement, the label is the one which is going to make the money out of it. It is very rare for a performer to actually have a stake in it, unless the agreement with the label actually includes that, saying that if this rendition of this particular song which I have sung gets placed in any movie or is taken for any other purpose, like maybe a brand wants to use it in an ad, then that amount that you give me a percentage of that amount. So these are all things which can be agreed to contractually as well. And I think now, of course, the industry is also talking about the fairness of all of this, and how industry practices need to be aligned with the laws, at least like the bare basic, right? And this is where I think it's important to understand the change that came about in 2012, which allowed composers and lyricists to retain at least 50% of publishing rights. So like I mentioned, so this is just these are this what I'm showing here right now is these are the possible owners of master rights and publishing rights. So who can own the master rights would be the artist, the record label, or the production house. And when I mean production house, I mean in the context of the film industry, right? So if I am a music director and I have been signed up, say by Yashraj Films to compose the soundtrack for their upcoming film. Um, Technically, because they are the ones who are funding the production of the music, they will own the master rights, and they are free to assign it to or pass it on to a record label for further distribution. And that's a commonly understood, and it is a fair industry practice, because there is no, you're not, at the end of the day, they have actually incurred all those costs in recording the tracks and producing the tracks along with the music composer. Here, when I say artist over here, I mean, um, in you might have noticed that there are a lot of times when the artist is a really like big artist and has put in his or her own money to record a particular track or to produce an album. They might also have a claim in master rights depending on what their agreement is with the person who is distributing the music. Now, in terms of publishing rights, like I mentioned, if you are an artist who has written, composed, sung, and distributed your own music, you will own both master rights and publishing rights. And the rest of it will be composer, lyricist, or the producer, the publisher. In all these parties that I've listed over here are all potential and possible owners of publishing rights, depending on what contractual agreement has indicated. Now, under law, going back to my first slide, um, after 2012, the amendment, the 2012 amendment allowed the owner, or basically the original composer or the lyricist, to retain 50%, a minimum of 50% of their ownership in publishing rights, which basically means that they were allowed, the law allowed them to retain it, and any assignment or waiver of that was held to be void. Now, this is where I'm going to go back to the main topic of the whole gap between industry practices and law. Now, after 2012, um, most industry practices didn't change. It is only after, I think, with the onset of online distribution of music, that people are taking cognizance of the fact that they are allowed to retain these rights. And by giving it away or being arm twisted into giving it away, they're actually losing revenue. So 2012 amendment basically did two big things. One, it allowed composers and lyricists to retain minimum 50% of publishing rights. And two, it gave performers an economic right, the right to monetize their performance. And that is how ISRA came into existence, the Copyright Society ISRA. Um, and I think what was also what do you think about the Indian time? The whole factory is so big and kind of controls how regulations have also shaped. It also means that the bigger players in the film industries are the ones who are kind of having a bigger say in how the regulations are shaping up. So you have production houses and record labels who have larger lobbies. So artists and performers and composers haven't been represented enough. So which is why the 2012 amendment was really important, because it was the first amendment that was made keeping the artist and the composer in mind, the individual in mind. And it had a lot to do with, like, a lot of hard work by some of the industry stalwarts, like, Javed Saab and Shankar Ehsaan Loy, and a lot of like has gone behind, a lot of joint work has gone behind it. And it allowed, uh, I think, artists and composers to actually negotiate and push back with production houses, and giving them the right to collect royalties which were earned by these production houses and record label distribution of songs over time. To think US, those who have one or two of the royalties for years together. And it's really sad that even some really big names in the Indian industry who have come out with like I think legendary music have probably passed away with nothing in hand, is very sad. And that has happened because of this gap between industry practices and the law. And there's nothing that has, um, I guess it's also, nobody wants to really like change the status quo, or there's like that fear of, if I push back on this, I will lose this opportunity. So that there's an inherent conflict, because there is a lack of unity within the artist community itself. Because if one artist stands up for his or her rights, there is another artist who will say, I don't mind giving it up. So that lack of unity is also a big problem. And um, the thing is, when we talk about independent music in India, we are just thinking of non-film music. But actually, you do have three segments, very proper segments. You have film music, you have non-film music, which is basically then split further into your classical music, your non-film actual independent music, which is released without a label, and you have non-film music, which is still affiliated with the label. And all these, in all these situations, the labels play a very big part. And it is not like how it was maybe 30 years ago, where labels had a responsibility to actually develop the artist and find an artist, like actually do some kind of A&R where they, you know talent scout and find a very capable young performer and invest in that person's career. Now in the day and age of the internet, where it is very easy to spot a talent who's gone viral, the labels are able to like just pick them up and say, okay, we will do so and so for you, and you will sign away all your rights to me. So that is where we are at right now. So I think what is really critical is to kind of emphasize the importance of awareness of your rights. So whether as a lawyer, or lawyer working for an artist, or working with artists, or as an artist yourself, these are very basic things which you need to like keep in mind, that you do have the right to retain certain things. You are allowed this, there is a statutory right that you have to collect royalties from a copyright society that you're registered with. You are allowed to retain your moral rights. You can't, you're not, the law does not permit you to waive a moral right. You will have an inherent moral right to any original work that you're putting out there. And now, talking about how, even in terms of how classical music works, I think that's what I first mentioned, like when we started the session. There was I think, a massive uproar because of the claims against, Carnatic compositions, which were on YouTube, and I think there were channels that were taken down because of copyright strikes, which were issued by record labels that had recordings of other people singing the same kirtis. So it wasn't even an infringement that came up because they were using the same sound recording. It was an infringement claim that came up because they were referring to the underlying work which has been in public domain for centuries. So here again, given how vague our laws have been, and given that technology has probably advanced a lot faster than our laws have, that gap is something which private players are trying to fix through technology, through algorithms. And I think even how copyright societies have worked historically in India has been determined by film industry stakeholders. So there has been a mindset that, if you don't belong to the film industry, then you can't become a member of the copyright society. That there is no point becoming member of a copyright society, which is unfortunate because that is not how the copyright society is meant to work. IPRS is supposed to be for anyone who owns their composition or who owns their lyrics, or written songs, original work, of course. So IPRS takes care of publishing rights, royalties arising from the ownership of publishing rights, performance royalties arising from that. So the people who are members of IPRS are publishers, composers, and lyricists. And these should be across industries. It's not limited to the film industry alone. That realization has probably, I think, dawned maybe in the last few years only. So there's been a rise, or there's been an increase in registering with the copyright society, like, artists registering with the copyright society, because they realize that they're actually missing out on collecting royalties by not being a member of a copyright society. And this applies to other copyright societies in different categories. Now, when I'm talking about categories, I mean that under Indian copyright law, there's only one copyright society is allowed per category of copyright. So under sound recording, there used to be PPL, which was then, they basically, there was an audit that was conducted and they determined that they were not a valid copyright society. So their position as registered copyright society was taken away. IPRS had they removed it from the status of deemed copyright society, and then they re-registered themselves. Basically, they kind of cleaned up their act. They've introduced a lot of like advanced technology. They are looking at online registrations, making things simpler for people to register with them. ISRA came into being after the 2012 amendment. But the problem with ISRA is that despite the fact that it's been doing tremendous work, given that there is only one copyright society per category, ISRA has registered itself as a copyright society under performers' rights. Now, a performer under Indian copyright law is defined as not just a singer. There is dancer, there is a sessions artist. So a sessions musician who plays on a song is also a performer. So by limiting itself only to singers, it kind of eliminated the possibility of the other performers on a work to receive royalties. Now, this is also a topic that is being discussed by industry stakeholders to kind of address and figure out whether we need to open up this aspect to have more copyright societies represent different parts of the copyright holders. Like in America, where you have multiple copyright societies for the same category. So you have BMI, you have CSAC, you have ASCAP. These are all copyright societies catering to composers and lyricists and songwriters themselves. And they are under different, like there'll be, I think one will be focused on pop rock, and there's one which is dedicated only to jazz artists. So we've been, I think there has been a discussion in the last 2 years specifically about this, the need to introduce more copyright societies for each category, so that every community is represented enough, especially sessions artists, because there are sessions artists who don't make any money out of, even though their songs have gone viral. And that brings me to the other part of how copyright law itself is designed to not include an arrangement of a song in the copyright. When they talk about a copyright, they're only looking at it as a melody and the lyrics. So the tune that you hum and the lyrics that go with the song. But the tune that you hum is just one aspect to that composition. The song comes together because of the arrangement, the flutes and the guitar and the violins, they all add to the melody. So I think we need to look at amendments which will include all these aspects in a composition, and not just look at it in a isolated, only the main melody kind of angle. And I think, of course, goes without saying that there has to be some kind of regulation which mandates a minimum payout to rights holders across platforms. So like a Spotify or an Apple Music or a Google Music, they all need to have, there has to be a regulatory mandate which says that you have to pay the composers whose music you have played, or whose music you have listed, at least X amount. Now, whether how long we're going to take to reach there, because it's taken America such a long time. They have, I think, regularized it only like in 2020 with the MLCC, the Mechanical Licensing Collective. And but I know that India has been like discussing this. We are going the digital way full on, and with the pandemic especially, I think everyone has realized the importance of figuring all of this out, especially the musician and the artist community. So I feel there has been a positive change. People want to understand how this works a lot better. The fact that we're even having this session, I think, is a telltale sign. So that this is from a very, all of whatever I've spoken about right now is from a very bird's eye view. Each of these topics can be discussed for hours at length, and there's so much of reading up that you can do, and it's been, I think, I've been focusing on this particular aspect in music and copyright specifically for the last 6 years. And in the last 6 years itself, I've realized every year there has been something new, some new development and realizations, which I've figured that you don't really have a one database access where it gives you everything. The only way we've actually been able to figure this out is through trial and error, studying how other countries have, handled issues like this, because there's no judicial precedent either. So that's my take on the the situation. And I wanted to leave some time for questions. I realize there are a bunch of messages that have been popping up, and I will. Okay, there's a lot of questions. Let me just
Yes,
take a
there
look
are
at them.
many questions in the chat box. We can take some of the questions because later on the 11 we should start with the panel discussion session by
Yeah, yeah,
Shubhaji and Aneesh.
yes.
Yeah.
Okay, I think I know there have been a bunch of questions that I've raised here, so I'm just going to look at them one by one and then
Yeah.
address
So
them if that's
actually,
okay.
one basic question from the musicians' side
Yeah.
that they want to know the basic difference between the patent and copyright, and what is the duration for each of them, and
Okay.
then what aspects of the music are covered under each of these IP rights, like copyright and patent.
Definitely. So
Yeah.
copyright, now a patent is applicable to an original process which adds value to an existing process. So like for example, patents are proprietary protection to something like a product. So if I've created a very new a new gadget which automatically turns on the light when I walk into a room and sets the light at a certain temperature, that is, and it's unique. So the uniqueness is what is critical. It has to add value on its own or add value to an existing process. That is patentable. You can protect it by applying for a patent. Now, patents don't apply to music, because music copyright is what applies to any artistic, dramatic, literary or musical piece of work or graphic, right? So when we're talking about music, the kind of intellectual property protection that we're talking about is the copyright. And you don't need to, like I mentioned, you don't need to register a copyright to establish it. If you have composed an original tune, and if your friend has recorded it on your phone and you upload it on Instagram, the second you upload it on Instagram, there's a copyright that is created in that tune, the recording, and the performance of that tune. So you don't need to go to the registrar of copyrights to copyright that particular tune. You can, the fact that you already have it on Instagram on that particular date shows that you have published it. I'm going to give you an example just for you to understand where I'm coming from. So like I'm taking the same example. You're the friend who has taken this video, has probably taken it on his or her phone, taken the tune back home, shown it to another friend, and both of them have made that tune a full length song and then published it on YouTube. Does that, is that infringing your right? It is. But is there any proof that you've published it before? You don't. So that is what I'm talking about. Like, if any prior data publication is what is going to be looked at. And the same thing applies to trademarks as well. So trademarks would be is a kind of protection that you provide to a logo or a brand name, which uniquely identifies you, your brand, or your product, or your service. And copyright is what is given to protect your original expression of an art. It could be a literary writing. If I had written a story and I published it on a blog, and if some newspaper has taken it and published it without my consent, I can say that they have infringed my copyright. Similarly, if I have sung a song which is original and I've put it up on Facebook, and if somebody else, some other composer has taken that tune and made a song out of it and put it in a movie, I have a claim against them saying that this is my copyright because I published this on this particular date. You have taken that tune and used it in your song without crediting me or taking permission from me. Does that answer your question?
Yeah. So we can take one more question.
Sure.
That one question is about, can or does the company have the right to delete the video posted by an artist on Instagram or any social platform, even though the due rights are given in the description? That is the first. And would any infringement issue arises? And if yes, then what possible actions can be taken against the one who posts it?
Okay, so I'm assuming you mean that if I am putting up, I'm going to take my own example and say if I put up a video on Instagram using a song which is not mine, but it is by the maybe it's like a popular song from the movie Ye Jawani Hai Diwani, and it is owned by, say, T Series. And if I've basically attached it to the video, I've taken a video of my dogs playing in the water and I put the song and I've uploaded it. Yes, the record label does have a right to pull it down because I have not taken permission from them to use it. And they have algorithms to kind of determine the fact that I have synced it without permission, which is why on most of these social media platforms, they have a listed catalog of songs which you can use to sync your video or your photo with, because they have already paid those record labels. Now, if I don't have the permission, even if I'm not using it for a commercial purpose, the rights holder has a right to flag infringement. Now, since today, most of these platforms are all algorithm based. Nobody is manually sitting and checking infringement requests. These are all algorithm based. So they will automatically flag it regardless of how I'm using it. Now, if it was, if it's not like how it was maybe 10 years ago. So things, along with technology advancing, there are these other problems as well, that even an innocent use of a song is flagged as infringement. So though you can claim that it is fair use, and that is where the exception kicks in. Fair use is where you are, either critiquing it, or you're reviewing it, or using it for an educational purpose, or just reporting about it. These are all the statutory provided exceptions, which fall under fair dealing, fair use. So unfortunately, it's again a process which is very difficult to establish in a large platform, any of these large social media platforms, because who are you talking to? There's no face, right? There's no personal connection over there. It is all like through bot chats. So so to answer your question, yes, unfortunately, the rights holder has the right to contest and flag your content for being infringing, and which is usually inevitably done through an algorithm. Now, if and I want to emphasize this whole rights holder bit, because a copyright infringement cannot be enforced, or copyright cannot be enforced by a third party. Only the rights holder can enforce it, or the person who the rights holder has given the authority to enforce on his or her behalf. So if Pratik, if you have seen a song of mine uploaded somewhere, you can't contest that song. You will have to tell me to contest that song, because I am the rights holder, not you.
Sandhya, can you just put up more light on PPL?
Yeah, sure. So PPL started off as a copyright society for sound recordings, basically collecting performance royalties on behalf of people who owned master rights. So most of them were record labels. What happened was, I think maybe 2013, around 2013, there was an audit that was conducted, and they discovered that there was a lot of ill practices which were impacting the transparency of how they operated as a company, and they were delisted as a registered copyright society. Basically, the status of registered copyright society was taken away. Despite that, they continued collecting royalties on behalf of companies that were registered with them, and now they have a transition from being a copyright society to an authorized agent. They are no longer a registered copyright society, so the law does not recognize them as a registered copyright society. So they just act as an authorized agent of a bunch of really large labels to collect royalties on their behalf, because they've established that network already. So you'll find them collecting royalties from venues. It could be large concert venues. It could be like hotels. It could be shopping malls, pubs, and anything which is a public venue and is playing music, either recorded music, for that matter, even concert music, because a lot of concerts also play the -1 track, which means the original master recording is being played without the vocal. So the concerts also have to pay royalties to the person who owns the master rights. And now, I think last year, RMPL has been incorporated as a registered copyright society for sound recordings. So there was a gap of a few years where India didn't have a registered copyright society for sound recordings, and now RMPL has come into the picture.
Yeah. Thank you so much, Sandhya. So few of the questions, they are still left, that those we can cover under the panel discussion, obviously.
Sure.
So,
Sure.
so thank you so much, Sandhya, for accepting our request, accepting our invitation, and throwing the light on some of the important aspects as to music and the royalties, and what are the gaps between the industry practices and the actual legal framework which we do have. So these all aspects, those are very much needed from the point of view of the artist, that may be from the point of view of the practicing lawyer, that may be the legal expert or the researcher. And again, I'm looking forward to your active participation in the panel discussion as well. So right now, we will end up with this particular session and we'll move toward the next session.
Thank you so much, Pratik. It's been a pleasure.
Yeah. Thank you. Thank you. So now we are going to move ahead with the next session by Padmashri Shubha Mudgal ji and Dr. Aneesh Pradhan ji, and they've already joined us for this particular session. I welcome Shubha ji and Aneesh ji in this particular session.
Namaste.
Namaste, 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 Aneesh ji.
Thank you very much.
I'm very happy that you have joined your hands together with us with the law institution, as because we needed to understand the intricacies between the law and the music, and you have done the great work in this particular field as to the performers' rights specifically. So this is our pleasure to welcome you both in this session, and I will introduce briefly both of you, and then we'll start with the actual session. So when few years back, I remember the mesmerizing performance by Shubhaji in Savai Gandharva Mahotsav, and it was a very wonderful rendition of Rag Maru Bihag. And from that moment, I am able to always, that is the fond memory with me. And later on, when I gone through the work which she has done, and along with you regarding the performance rights and all those things. So obviously Shubhaji needs no introduction, as because she is known to the musical world in India and across the world as well. As far as Aneesh ji, you have carried out again, you are one of the leading tabla players in India, and you have got the inheritance of the tabla from Nikhil ji Ghosh, and you have got the several awards as well. Aditya Birla Kala Kiran Award, that may be Natya Darpan Award for Best Background Score in 1998. That is again Vasantotsav Award, which you have got in 2012. Then Sat Sangat Kalakar Award in 2013. So these, all of the awards and whatever the research work and whatever the work which you have carried out, that gives you the different identity in the field of music. And I welcome both of you for this session in 2-day National Symposium on Law and Music. And now I would like to request Dr. Kranti Deshmukh ma'am, principal of Marathwada Mitra Mandal Shankarrao Chavan Law College, to say a few words, and then we will start with the session. Over to you, Kranti ma'am. Kranti ma'am. Just a minute.
Can you hear me? Yeah.
Yes, ma'am. Yes.
Sorry, I think there is some technical error because of technical glitch. Because of that, I was facing some problem. Very good morning to all. The second day of this National Symposium on Law and Music, and for this session, I heartily welcome respected Shobha Mudgal madam, Aneesh Pradhan sir, and Chaitanya Kunte sir, and coordinator of this National Symposium, Pratik Salgar sir. We are very happy to have you for this session. We are very delighted and grateful to you for accepting our invitation. And I cannot express in words how happy we are have to have such a panel with us in this 2 days national symposium of this law and music. Shubha, Mudgal madam, Aneesh, Pradhan sir, definitely this session is going to be enriched session of this 2 days national symposium. On behalf of Marathwada Mitra Mandal Shankarrao Chavan Law College and Lalit Kala Kendra of Savitribai Phule Pune University, I extend my warm welcome to you, and we are definitely looking forward for your address in this session. So without wasting much time, once again, I heartily welcome all the participants, dignitaries, guests of this session, and I request Pratik sir to proceed further.
Thank you, ma'am. I again welcome Shubhaji and Anishji, and I would now like to request both of you to start with the session and express your opinions. Thank you. Over to you.
Namaskar to everyone, and our thanks to the Shankarrao Chavan Law College as well as to Lalit Kala Kendra Pune for giving us this opportunity to be part of a very important symposium for us. But it's on a subject, in fact, in which we have no training. We are perhaps the most underqualified to speak on this subject, and yet it's a subject that impacts us very significantly. So what Aneesh and I will comment on is purely from the personal experience that we have gained as being students of music and performers in this field for several decades now. I'm also very, very grateful to Sandhya Surendran, whose work I really admire, for putting forth such a wonderful, a kind of bird's eye view of the manner in which the rights of artists can be protected and managed. Of course, the law really serves every genre, every person who comes under its purview equally. And yet, I feel it's important to state right at the outset that we are currently governed by laws which are extremely Western centric and have not taken into account the specificities and peculiarities of Indian traditional music, including Hindustani classical music. And perhaps a lot more discussion is required for us to be able to both implement laws as well as perhaps have further discussions on how to protect them, because of course copyright and IPR issues are very important, but there are other issues which are also governed by the law in our country. It is a very, very artist friendly law that has been created for performers, creators, artists in India. And yet, many of us, you will find many of us saying that the implementation of those laws is perhaps far from satisfactory and perhaps not as inclusive, which is why I'm particularly grateful to all the organizers of this session, because normally we are not even part of discussions regarding law and music. Even though we are stakeholders, very often we are not included. So I'm really, really deeply grateful. Aneesh, would you like to say something and then we can go forward?
Yes, thank you to everyone for having invited us, and good morning to all of you. If I might just begin on a lighter note, Pratik, you left out one important thing in our biodata. We are notorious as troublemaking musicians, in this respect, because everyone for the past at least 2 decades, if not more, Sandhya ji says the best kind. So
Yeah.
I'm not too sure whether our colleagues would like to hear that. But really speaking, as students of music, we do not learn anything about the law when we are learning either in the Guru Shishya Parampara or in institutionalized training. It is only of recent that some institutions have begun taking up some courses, and we were also responsible in some way to introduce one course at Flame under the guidance of Dr. Ashok Ranade, where we decided to engage students with the study of contracts and what the IP law suggests, etc. So this is really an area which we feel that students, performers, scholars need to really study very carefully, particularly in the world that we are living in, where technology plays such an important role, and where things about IP are changing constantly, and we're also very thankful. Sandhya ji mentioned about Javed Saab's role in the path breaking role in the recent amendment to the copyright law, and we're really happy that he brought together so many individuals from the music world, and Shubha was very fortunate, and we are all very fortunate to have Shubha as a kind of a representative when those meetings were taking place, because the representation of traditional music, in a sense, was done by Shubha when those discussions were taking place. So I'm really thankful to Javed Saab also for having spearheaded that amendment. Shubha did mention that the copyright law, while it's very artist friendly, it's the execution of it is very often film centric, Western centric. And if I might give you just an example, the very fact that you talk about everything related to the law through the lens of a song. I am a percussionist. I belong to a long tradition of percussion music through the tabla. We have 6 traditional schools of tabla playing, which have enough solo repertoire that can last for hours and hours and hours. That has been composed since around the mid-18th century. We know the names of the composers as well. There's no melody, there's no lyric. What happens in this case? The lyric consists of mnemonic syllables, which we recite or reproduce on the tabla. How is the law going to determine copyright in this case? And who is actually efficient enough in the judicial system to determine that I am the composer of a particular tabla composition or a pakhawaj composition? So these are elements, I think, that we will have to look at very closely when we are thinking of taking the law forward and trying to see what kind of further amendments can be. This is just one example I was giving. Secondly, Sandhya ji did mention that this being traditional knowledge, I mean, the Rag Tal system and a large part of the compositions also. Of course, we do have composers today also. Chaitanya ji is, for instance, a composer today. Shubha composes. I compose. So many people compose even today within the Rag Tal paradigm. But in the case of Sandhya ji mentioned what the law states and what should be the ideal scenario. But industry practice tells us otherwise. Musicians have signed contracts which clearly state that whatever they have played or sung, not just the sound recording, but even the content, the repertoire itself is transferred to the publisher. And which is actually not belonging to us in the first place. If I sing a Sadaran composition from the 18th century, it doesn't belong to me. So how can I give it to anybody? but that's what the contract says, and this is the reason. And the problem is because musicians have never read the contract. The unfortunate part is because of the, and I understand the pressure of a musician to earn his or her living. So therefore, what is most important to the musician uh, in general is the check at the end of the day. They are not so bothered about after 10 years what royalties am I going to get, or whatever, or what is my family going to get. So they're just wanting to finish. Yes, sorry, somebody said something. Okay. So they just bothered about what amount they will get immediately after the recording. And this is the problem area. And this is why the record labels manage to claim ownership of the repertoire as well. Shubha, would you like to go forward?
Yes, I think it's important to mention here that our experience has been that very often all negotiations, either for live concerts or for recorded albums, very often just hover around the fee to be paid. The terms on which you will perform or record for a music label are very often not really thoroughly discussed. It is important to mention here that we are using material which is actually traditional knowledge. I could be singing a rag which never belonged to me, has cannot actually belong perhaps in except in some cases to the person who made it. So we are all using this knowledge, this great pool of ragdari knowledge, of tals, of compositions that have been around for several hundred years. But the improvisatory nature of this music is equally important. And if that is so, and if we acknowledge it, then in that case, it is very important that we also acknowledge that the improvisation is not done alone by the main performer. There is an improvisation which is also happening with the accompanying artists. Now, the law, of course, obviously states that the rights of all the ensemble, every member of the ensemble, are equal. But in actual fact, there is quite a hierarchy, and that hierarchy plays a very important role. Often, if there are contracts, in the rare instances that there are contracts, particularly for live performances, they would be there only with the possibly with the main artist and not with the accompanying artists. Therefore, are we saying that we are going to allow accompanying artists not to be covered by the law? Also, they have played an important role in improvising on the spot. So should some part of that improvisation, should they not have a role to play and reap the benefits, if any, of that improvisation as it is recorded? I think those things have not been discussed in great detail, and it's important because we are dealing both with traditional knowledge, but with traditional knowledge which is elaborated upon, and that contribution, can that elaboration be copyrighted? Can that elaboration then belong to anybody singly or as an ensemble? Also, if I'm using traditional knowledge, let us say that I want to make a very sincere an honest effort to learn folk songs from Uttar Pradesh, from where I was born in Uttar Pradesh. Now, if I learn that material and I choose to record it, who do I acknowledge? Do I say that perhaps it is a wedding song that was part of my father's community? Who do I acknowledge? How do I document, first of all? Because, first of all, leave alone the business angle. It is important that as students of music and as people who are taking forward an inheritance, we mention that this belongs to somebody, that we got it from so and so community, or we received it from so and so, we learnt it from so and so community. And if we do, then how do we acknowledge, and what happens if we acknowledge? Because as you are all aware, perhaps much better than both of us, that there have been many disputes about, let's say, the use of folk songs. Now, if in all fairness, I want to learn a folk song and use it, can there be multiple claimants saying that this comes from my community, you should have paid me as well? Why have you not paid me? In that instance, who do we pay? Which community do we pay? Is there a community, somebody managing that community knowledge? And these issues have not been discussed in the very few discussions that I have been fortunate to be part of. When the protection of traditional knowledge was being discussed on formal platforms, I found that the formulae used for, let's say, Ayurveda was often thrown at us. It's been done with Ayurvedic, so can it be done for music? But how can it be done? Can the same formula apply to music, particularly music that is so diverse as the kind of music that we find in India? So both in in the situation of a live performance as well as in the situation of recorded work, this issue is not taken into consideration very often. I can tell you, my first recording took place sometime in the late 80s. There was only a phone call in which my fee was discussed, no repertoire was discussed, nothing else was discussed, and the contract was sent to me approximately 2 months after I recorded, and the cassette was already out in the market. I did not, I mean, I'm a literate person, so I was able to read the contract and I was horrified at what I was reading because it clearly stated that all those rags that I have sung and recorded cannot be sung by me without the prior written permission of the music label. Now, I mean, this is, if you read it and you understand what you're reading, this is frightening for an artist. That how do I stop singing Yaman, Kedar, Bageshri, Malkons? And how do I promise them that I'll never sing this ever again without written permission? So we are all, even today, I can vouch for it that we are signing contracts like this because these contracts have been, they are based on templates which have been modified a little by very often by multinational companies working in India. And so any changes that you ask for, you are told, nahi, ye change nahi ho sakta. It can't be changed. It is written in stone. You cannot change it. And now it has come 2 months after you have already recorded and the cassette is already out in the market. What change are you going to fight for? Plus, you are up against a huge, I mean, the law may be friendly, but what happens to poor old artist who has been paid a small amount? What was I paid in 1987 for a recording contract? I mean, I know you people will laugh at it if I tell you what I was paid. The fee that is required to fight this and challenge this in a court of law, I mean, it is ridiculous. It's like the balance of power is totally skewed, and the time that would be taken, the resources that would be taken, I would not even be able to pay for the photocopying of all that paper, if I was to balance it against the amount that that I received as my full and final fee along with the company's fee. So I think these issues really need to be looked at very carefully, and the improvisatory nature, the spontaneous decision of what you are going to sing. Do we ever submit a set list in any concert saying that I will sing this? I may plan for it because I have a fair idea that I will start, let's say, at 6:30 in the evening, but it's possible that the concert is delayed for some reason and I start singing at 8:30, in which case I will need to change what I had planned and sing rags that are appropriate for that time. So my set list, if I even submitted a set list, that goes flying out of the window. So how will my performers' rights be collected for that? Anish, would you like to add?
Yeah. So, of course, a lot of this discussion is about the our recording for the industry, for publishing through record labels, and I don't know whether it's a fortunate thing or unfortunate thing that record labels over the past decade or so are not really recording anything new from traditional music performers. So whatever new recordings you're seeing of Ragdari music or even folk music is primarily coming from independent labels, small labels, or even from the performers themselves. And there we can really, think of the contracts in greater detail. If it's a huge multinational corporation or a huge record label, it's very often forbidding for musicians. They just feel that, oh, such a record label is recording me, and that's just about it. I have to be beholden to this, and they don't think about. And the moment you start discussing contractual terms, first of all, you stand to perhaps lose that contract. Secondly, unfortunately, your colleagues actually, they look down upon you, uh, and they feel that, oh gosh, we could have done that recording, but this person always makes trouble and discusses all these details. So, well, what is the harm in doing the recording? And this is the problem. And after such uh, issues have happened, we have come across friends in the fraternity, musician who have come to us after 2 years, 3 years, 4 years, and they say, this is what happened. And when we say, why didn't you think of it in the first place? What to do? We would have lost that opportunity. So this unfortunately is a problem. There's one important thing that Shubha and I would like to highlight, that when we're talking about law and music, of course, a large part of the discussion revolves around IPR. But also we feel that the law extends to also other contractual details which may not necessarily relate directly to IPR. So we would like to touch upon those briefly also. And we'd like to lay out a few of the scenario, what happens in a typical situation for traditional music, or particularly Hindustani music that we are aware of. So first of all, there are different situations for live concert, and there are different situations for recording for a label. So let's look at the live concerts. Typically, the organizer will call you, make a date, etc., etc., and probably send you an email. Earlier, it used to be an inland letter or whatever. Now it's an email. Normally, there's no contract. Years ago, we worked on templates, model contracts for music circles, festivals, or festival organizers to enter into, not just with the main artist, but with accompanists too. But we discussed this with major organizers in Mumbai. Nobody was interested in signing this. They said no, and they put the onus actually on the musicians. They said that, oh, the main artists will not want to sign this, which is not true actually. They too didn't want to be held down to contractual terms. So one of the major terms that we mentioned in that was related to our performers' rights. And normally, nobody takes permissions for recording of a concert. The law states, the copyright law states, and Sandhya ji, please correct me if I'm wrong, that you have to take permission, a written permission from a performer, and the performer can be even a snake charmer, or a musician or whatever, for a public performance to be recorded, you need the permission of, yes, so thank you, Sandhya. So you need the permission, written permission of the performer. In our case, normally these permissions are not taken. If indeed they are taken from only the main artist and not from the accompanying musician, because a sort of a hierarchy exists in the field. the main artist feels that, "Oh, I don't need to take, have the accompanying musician say anything. They're just going to be given a concert fee and that's it." And so now what happens to this live concert recording? I mean, typically even a public lecture, for instance, this session that we are having, we need to have permissions from all the participants here that we are recording them and for public dissemination later on, or for whatever purpose, even for archival purposes. So that written permission has to be there. Unfortunately, in the Hindustani case, it is not there. And now with Facebook Live and Instagram Live, etc., you just are, you never know when these things are going to happen. Forget about the payment part. Just ethically and legally, this is incorrect. And it is time that musicians first realize that this is wrong and then enter into negotiations with organizers accordingly. Secondly, when these recordings are made, they are often touted as something that is going to belong to a large repertory, a large archive. Normally, the archive is just a personal collection of some organizer and remains in his or her bedroom. An archive should be for public access, just like a library. But in our country, archivists, many of them become, and private collectors, they become so proprietorial about the material that they have. In the first place, they did not have permission to record it. Secondly, if they had permission, they need to prove what that permission was given for. Was it for being a part of an archive, or was it for public dissemination? If it was for public dissemination, was it for are not ironed out uh, at the outset, and which results in a lot of rancor and problems. Shubha, would you like to go ahead? You're on mute, I think.
Yes, I think it's very important to for an archive also to have a very clear-cut archival policy which is shared with the person whose work you are going to include, or the person or the persons whose work you are going to include in the archive. Is the archive going to disseminate free of charge, or is it going to be a subscription-based access to the archive? A large number of music archives have come up where people have submitted recordings which, as a performer, I never knew existed. I think it's also important to look at the moral and ethical right of a performer. Do I want every performance to be available for public access? It is possible that I may not want a particular performance to be available and accessible to the public for a variety of reasons. It may not have been, I'll be honest, it may not have been my best performance. I do not want that to be a record of my work. Or there may have been serious glitches with the sound. There may have been serious problems with various other issues. For example, acoustic instruments constantly needing to be tuned because of weather or climate conditions. That's not a recording that I would want put out in, or made accessible to the public. And perhaps my accompanying artists also have reasons to not want a particular recording to be accessible to the public. I think archival policy, particularly for traditional music, needs to be stated, permission needs to be taken. Yeah, Anish, please.
Yeah, I was just wanting to give them an example uh, of such an archive, because when we are talking about all these issues, it pertains not just to non-government organizations. It pertains to government organizations as well. The law is the same for everybody. So, I mean, supposed to be the same for everybody. It's a different matter that people flout rules. For instance, the National Cultural Audiovisual Archives, which is the abbreviation is NCAA, was set up by the Ministry of Culture at IGNCA in 2014. And it was slated to make 30,000 hours of audiovisual material available in public domain through its web portal. Okay, now this is an important source material. For instance, a lot of Hindustani music recordings are there. We found ours also. We didn't know that those live concerts had been recorded in the first place, but now we find that they are on this NCAA website. But we had some important questions. For instance, the NCAA project report mentions that due diligence has been made with regard to intellectual property rights for the material. So we would imagine that on an ethical and legal level, representation of the artist fraternity on the committees that have been heading this project would have been done to establish transparency and credibility of the process. Was there such representation on these committees? Were artists consulted before making their work available for public access? Were written permissions sought from them when these recordings were originally made? And was there a clause that allowed the institution to share their work without further permissions? Now, I asked these questions to the person who was heading this project. Unfortunately, I did not get good enough answers. First of all, the answer was delayed by several months, and then it was not good enough. I was directed to the website. I had already checked the website. All these things are not mentioned there. So what do I do now? This is a quasi-government body. How am I going to, as an individual performer, look into this or defend my rights? At the drop of a hat, if I have to go to the court for every little thing, can you imagine what this would cost? Forget about, I mean, the time and energy that I have to set aside for this, but just the costs are humongous. So I think, I mean, whether it's particularly government bodies need to really think whether they are following the rule of law. Otherwise, there's no point in having, policymakers can make all kinds of amendments, etc., etc., and it looks very good on paper. But if it's not going to be executed in the right manner, nothing is going to really change. And while I'm on the aspect of government bodies and contracts, look at, for instance, the contract that we signed for All India Radio programs. I have been performing on All India Radio since the 80s. Okay, first as a young artist, then onto as a graded artist, etc., etc. We all signed the same contract, and the same contract exists today. We love tradition, but some things have to change in tradition. The tradition stays alive when it's not stagnant. So, but unfortunately, we don't think of that when it comes to law and contracts. And let me read out one of the clauses in the All India Radio contract, and you'll see how dated it is. Clause 5 of the conditions referred to in the offer of engagement is an example of this inequitable arrangement. And I quote, "All India Radio shall have the absolute right of rejection of all or any part of the entertainment submitted by the artist, and shall not be called upon to give any reasons for any such rejection. Should the station director reject all or any part of such entertainment, the artist shall, with all dispatch, submit other matter or material in place of that rejected for the approval of All India Radio. Can you imagine this unilateral kind of arrangement? And all of us, we continue to sign these contracts because as individual musicians, we can't really challenge this. We have had the best known legal luminaries as policy makers, but none of them have thought it wise to reconsider the clauses in these All India Radio and Doordarshan terms and see that these are changed. I think government bodies too need to, even in government functions, when we are performing in government functions, you see video cameras everywhere. After that, then we see those recordings being used on various platforms, and without any permissions being taken from us. And when we do challenge this, or when we ask them in the first place, are you going to record it? Because now we know by now that they're going to record it. So when we ask them, we are seen as troublemakers. So I think if musicians agree that all of us face such problems and we need to have a united stand against all these matters, nothing is really going to change, however many great amendments you may have in the copyright law. Shubha.
Yeah, I'd also like to mention, since we mentioned All India Radio, AIR, that the one good thing that they do is that they have separate contracts with each performer. So,
Yes.
and also the gradation process is applied to all artists, whether they are accompanying or whether they are the main performers. So, in a sense,
It's
some
democratic.
yeah, it is democratic because each person has a separate contract, and it is even possible. I mean, I've had several instances where and the accompanying artists were graded higher than me when I started singing. They were graded much higher than me, and that I think is a welcome situation where some sense of fairness and a democratic approach is applied by All India Radio. But as far as contracts are concerned, they're very lopsided. You cannot object to recordings of your contract being used for anything. I think even moral rights are taken away from you, which I feel is such a fundamental right that you're being stripped of. I think that is an unfair thing to ask for. Why should something that I have recorded be used for a cause that perhaps I might be against? I might not want an alap that I did to be used, let's say, for an advertisement for cigarettes because I don't like smoking. So if I want to say that no, I don't want this piece of music to be used for that, unfortunately, if I've signed a contract with AIR, then I cannot say that. It will be used. I will be paid a certain amount, but I have no right to say that no, it can't be used. And I think that is really taking away a very fundamental right, which I cannot really agree with.
We're almost coming to the close of our session, and then we'll open for question answers. But a quick thing that I wanted to add, because we're talking about contracts, we need also to look beyond what happens in the country itself. A large group of us, we perform across the world as well. And when we perform across the world, earlier contracts were not in place several decades ago. But as we've moved on, organizers there, whether Indian or non-Indian, and us, we have realized the need to have contracts in place. But even now, very often, the contracts are only with the main artists and not with the accompanying musicians. One major departure from this was made by Dr. Balwant Dixit when he was heading the Center for Performing Arts in India at the Pittsburgh University of Pittsburgh. and he had literally hundreds of programs across several years, and he would have very transparent dealings with each of the musicians, both in terms of the rights involved, the accounting. Everything was done immaculately. So I don't see why that cannot be done today. And with all the technology at hand, we can do this. It's just that we don't seem to have the will to do it and the courage to do it from the musicians. So shall we open for question answers? Because it's 11:45.
Yeah, we can.
Yeah.
We can. Shall we start?
1 minute.
Yeah,
Pratik,
yeah.
just one addition I wanted to make. Sandhya ji was
Yeah.
talking about patents, and she was telling us the
Yeah.
difference between patents and copyrights. Just one addition, if I may, Sandhya ji, that with regard to patents, if I'm making a change in my instrument, for instance, Ullas Bapat, he had patented his kalam, the strikers for his of his santur, because he had added a metal strip where he was holding the kalam, and that allowed him to glide across the string to produce mead. So he had patented that. So instruments or changes in instruments can be patented. Thank you, Sandhya. Yes, sorry, Pratik, please go ahead.
Yeah. So now I would like to request to Sandhya ji and Chaitanya Kunte sir to join this particular session for the panel discussion, and we can discuss some few more questions which are coming from the participants. So one of the important question that we got from all the participants, for which maybe Shubha ji and Aneesh ji, you may answer that. The there are the problems which you have discussed regarding that, may be regarding the contracts, that may be regarding the rights which are being violated for the performer, or that may be for the accompanying artist. So the one question that remains very important, that how to create the awareness among the musicians and the artists who are unaware about the intellectual property rights and who are unaware about their performer rights. So what may be the different ways to create the awareness among the artists and the musicians?
May I answer?
Yes, yes.
I think there is no easy solution, but one of the things that could perhaps be incorporated is a paper in formal courses which discusses this issue and makes students aware of what lies ahead for them. I'm not saying that they would become legal experts, but at least what their rights are and what rights they can ask for and how they can get help to manage these rights. This needs to be explained to them. Without that, let me say that every course, successful course in any institution, often aims at providing help in professionalizing things. So if a student of music is to become a professional musician in today's world, I think one way of equipping them with this information is to explain this in their course itself. How do you, when you become a professional musician, what is it? What are your rights that you can ask for? How do you manage them? Do you need professional help? I think that is very important. Other than that, I also think that it's very important for us, for policymakers. Sandhya ji referred to this very often, that a minimum payment should be made by, let's say, people who are collecting licenses. I think it's also very necessary for organizations, particularly those that claim help and grants from governments or from other associations and other fund providers. If public funds are being used, then there has to be a proper fee that is given to the artists, which also includes some funds for through which they can have contracts vetted or consult legal experts. Otherwise, the law is there for the artists, but it is too distant from them. When an artist is being paid a total of, I know, please don't laugh at this, but a total of 10,000 rupees or 7,500 rupees to come from any part of India to Delhi, New Delhi, to come and perform, and that includes their travel and payment to accompanying artists. They may also be given 1 day's accommodation and hospitality in the venue. What what legal help can that artist get from this amount? So I think if the law wants to be truly friendly, then there has to be a way for artists to be able to make use of legal help, whether it comes from people who are offering this help. Yeah, Anish, please go ahead.
No, I just wanted to add that help from outside and getting this streamlined through your various courses in universities, etc. That's fine, but I think musicians themselves also need to realize the importance of this. Very often, and increasingly so, family members of musicians have started organizing programs on their own. Everybody wants to be an event manager, okay? And more so, if you're not a good performer, then you become an event manager. So, and then using their good offices with other musicians, they invite them for performances and record them, and then publicly disseminate them either through Facebook Live, this, that, whatever, even sell it to commercial record labels. And this has we have been witness to this happening, and some of it to happening to our own work. So I think musicians and their families also need to realize that they need to stop this exploitation of members of their own fraternity before thinking about other organizers.
Yeah. So there is one more question, which is very important to be discussed on this particular platform. That being a Vagyakar, is it possible to patent or copyright the self-created rag? That is the first issue which is to be brought on this particular platform. And secondly, from the moral point of view, should we do this, as because that may ultimately hamper the spontaneity of an artist due to the legal part which is coming into, we can say that patenting or copyrighting that particular raga or any composition which we have created. So please throw some light on this particular aspect, Shubhaji, Anishji, Kunte sir, and also from the legal point of view, how this can be legalized. Please throw some light, Sandhya. Yeah.
You want to go first, Sandhya ji? Oh, you're on mute, I think.
Yeah.
Actually, I'd like to add on, because since this is also about patenting a certain kind of a rag, I'd like to hear what you all have to say and then add on from a legal perspective.
All right. So I think the issue of patent doesn't apply here. It's the copyright that
It's copyright.
yeah. And if I understand the question correctly, the person is asking whether this will in any way hamper creativity, is it? Or the further dissemination of this material?
The question is about whether it is possible to copyright the self-created rag.
Okay. I guess it is possible, right? I mean, you can register your work, Sandhya ji, with the Copyright Office. Yeah, you want to tell us about that? Earlier, we used to do this, we used to record the material and send it back.
Mail it to ourselves, yeah.
Yes.
Yeah.
I still have some packets like that.
So I think this is something which we had discussed even in my session,
Yes.
that about registering a copyright, there is no mandate that you need to register a copyright to establish it, as long as it's published on a particular date and you can establish that publishing,
Yes.
which is easy today, given that the timestamps can't be modified. a lot of people mail themselves a copy of a composition. So if it's a original rag, then how you can establish a copyright is by, like, maybe uploading it onto a SoundCloud. I'm saying these are the non-legal, so to say, methods of establishing a copyright. If you'd like to register it, that's something, that is a process that you can follow with the registrar of copyrights. There is a form that needs to be filled. It's a 500 rupee process, and it probably takes like anything from like a month to 90 days, sometimes quicker. There's no real actual fixed time frame for it. And again, like I mentioned, having a registered copyright just gives you the benefit of not having to prove that you are the owner. But there are instances where you've had someone else register a copyright of us on a song which was originally composed by someone else, and that has gone to court, and you can still establish that you are the one who owns the copyright because you've published it elsewhere and not registered it. So that it's always about the first date of publication, which is going to be given the most importance.
So, is there any connection between copywriting a self-created raga with the spontaneity of an artist?
So I think this comes down to the concept of copyright itself. So why it was even introduced like back during like the French Revolution era was to ensure that people who are coming out with original work are being rewarded for it, and also being able to protect their work by not having it plagiarized, but not in such harsh terms that it prevents and kind of suppresses creativity itself, which is why you have people who have covers of songs which are originally written by someone else and who are creating money out of it. So there is a procedure for it all. So even if there's any enforcement, it lies at the hands of the person who owns the copyright. So if I am not taking offense to someone using my work and creating something new and original, it's up to me whether I want to flag that as an infringement or not, which is where the whole concept of moral rights also comes in. If I'm not being acknowledged for it, and if that person is taking credit for my work as well, then I have cause for concern. But if I'm being acknowledged and if I'm being credited, and if there has been a procedure which has followed, which is including taking a license to use it, to maybe monetize it further, then I don't think there is a curbing of creativity over there. It is just about putting a procedure in place so that all sides are taken care of.
Yeah. Shubhaji, do you have any opinion regarding this? You're muted.
Yeah. I really don't see any curbing of creativity because I don't think creativity can be curbed. It's in the sharing of what you want to do and in the manner of sharing that any issue can come up, as Sandhya ji said. Nobody can stop me from sitting in my room and being inspired by somebody else's creation. It's only when I want to also share that with somebody else that I need to take permission. I don't think you can curb creativity easily. But I think, yes, when you want to share it and want to monetize it further, then these issues come up.
Yeah. So that is, I think, now, yes, Kunte sir.
Yeah, Abhijit, who asked this particular question, I can respond to him that yes, you can publish your work and claim as your original creation. And of course, you can give permission or grant permission in that publication, like anyone can sing or perform this with giving due credit. That's fine. There is no other need or procedure to follow, I think. Am I correct,
Yeah.
Sandhya ji?
The one thing though I would like to add here, and this is from something that stemmed in a seminar that we had organized several years ago on a similar subject, that for instance, you have let's say books of compositions, and I'm not saying those that lie in public domain, but which are published just recently, and whether or not the composer is still alive, but the family is there. So if somebody chooses to record those compositions and then publish them, for non-commercial or commercial gain. Can you do that? And we understood from the legal experts that that cannot be done, because they said that there's something called migration from one format to another. Is that right, Sandhya ji?
Yes, so that is effectively creating a derivative work of the original.
Yes, yes.
And so even if it's after the lifetime of the author, there's still a 60-year period for it to like actually move into public domain. And even if it moves into public domain, it's not like the author's moral rights kind of go away. You still need to credit the author with it. So even if you're having that recorded as a song, or maybe transcribed into a poem which is being recorded and then published, you still need to credit the author. And if it's not within public domain, ideally you still need to, I would think that there is a license fee that needs to be paid. There has to be, because that's the only fair way of looking at it.
Absolutely. Shubha, do you want to touch briefly upon the OTT platforms and what that is doing to traditional music?
Yeah, as far as I understand, I mean, I have very little experience, but OTT platforms, I think, are quite insistent upon acquiring all rights in perpetuity for everything under the sun, galaxy, whatever. It is like a complete stripping of all rights, and this is happening. Although everybody says that the law does not permit such blanket assignments, and yet this is happening, and there is no regulatory authority which is saying why is that happening. A confidentiality clause also makes it imperative that we do not share information about this. But I think this is this can be a difficult situation, particularly for any artists who are also dealing with traditional community material. And then, I mean, on the one hand, you could say that technically, if you don't own the rights of this material, how can you give them to anybody? But you are giving them, and you are being forced to give them for a platform which is now so widely popular. Ideally, it should be possible for creators to share their work on any emerging platforms, because that becomes another source of revenue. But this kind of contradiction in the implementation of the law is particularly baffling for people like us, who are saying, but we ran around wildly with Javed Saab trying to get this law amended, and it was amended, thankfully, unanimously in Parliament. And yet here we are, everybody, is insisting on blanket assignment, and we are also signing those. So I think these contradictions perhaps also need to be first brought out into the open. I don't know how it can be done with that confidentiality clause in place, but they need to be called out and perhaps discussed and something done about those.
Thank you for bringing that up, Shubhaji. That's something which I've constantly dealt with the artists that I've worked with as well. And I've realized that I know it might be a shameless plug over here, but having a lawyer has made so much of an impact, because especially someone who understands how the industry works and how this rights distribution itself works, and the fact that the law allows you to even invalidate a contract which is contrary to it. So a contract that's void ab initio doesn't even bind you to that confidentiality, then technically speaking. But of course, nobody wants to burn bridges. So there's a cultural change also which needs to come into place, because I think there's that entire concept of, if I don't sign up to this, I'm missing out on an opportunity to get more, and that kind of ends up having you undercut yourself and someone else also in the process. So this has been an advice which there's a dialogue that I've had with the artists that I've worked with as well, saying that you don't need to think of losing an opportunity because you are signing away or refusing to sign away your rights, because this is something that is given to you by law. And technically, the minute you stand up to it and you push back on it, I've seen more often than not the platforms are willing to let go, because they know that they don't want this to be challenged in court. Because if it's challenged in court, the contract is just going to be thrown out.
Yes. Actually, interestingly, technology, for example, on Zoom, the moment you enter a Zoom meeting which is being recorded, it informs you that it's being recorded and you have to accept it. And nobody says that Zoom is being difficult in asking for this, for this permission. We all give it happily. But when an individual gets up and says, no, I don't want to be recorded, or I'm happy with being recorded, then there is an almost like a, oh, why is this person being so sticky? What is wrong? Also, I think around the idea of the arts, there is, at least in our country, this almost this idea that talking money is not correct. That means you're not that much of an artist.
You have to be poverty stricken.
Yeah.
So,
And if you are not clean shaven or something, that is even better. Just down and out.
then Chaitanya ji wins over you, Aneesh.
I think Kunte sir wanted to add something in this discussion.
No, actually, I just wanted to have the question which is posted by Neha Muthian, who is a Kathak dancer. And that question actually comes many times, like asked by many dancers and many musicians. So she asked that I'm a Kathak dancer by profession. If I perform on a pre-recorded track from a CD or a track that I purchased, am I required to make any payment or still take any permissions to perform on that track? So, what is the answer, Sandhya ji?
Okay, so there are a few aspects to that particular question. So when now in this particular instance, she is performing on a track from which is being played off a CD that she has purchased. So the right to use that CD is for personal uses alone.
Right.
So it depends on how that performance is being viewed. So if she's going to record that performance and then publish it, then there are certain things which will get triggered. There are certain aspects which get triggered because she might not have a license to sync that song to that video recording. So if the copyright holder decides to raise a flag of infringement on that particular social media platform, they still can. The second aspect would be if she is releasing it, say either on a YouTube, and then if this song already exists as a video posted by the original label, there'll be an automatic infringement claim that comes and strikes it down on YouTube. Now, if she's doing this on her own at a dance hall where there are people coming to watch her perform, then the organizer is responsible to take permission played, which is where you have your copyright societies collecting performance royalties of that particular track. So these are the different aspects. Like you have three categories in which it's going to have an impact. But if it's a private performance or which is not being recorded and published, then there is no additional permission that you need to take. I hope that answers Neha's question.
Yeah, I can add a little bit in this regard. Like even if the dancer is not using a recorded track, she is using a song or a composition. Like I have composed several songs or compositions for dancers. Now, I only want one thing to do done by them is to acknowledge it. I don't demand any money or remuneration for that, but at least they should acknowledge that so and so is composed by so and so, or it is performed by someone. Like if they are using a recorded track of that composition, then they should acknowledge that who are the composers, who are the singers and musicians in that recording. That's it. But we don't get even that many times. So
yeah,
that's
so I think that is more about the moral duty.
Moral right.
Moral duty.
Right. Yeah. That's the moral right to be credited and acknowledged as the author or composer of a particular.
So when as rightly pointed out by Chaitanya ji about the moral right and the duty which is to be followed by the performer by acknowledging that particular composition and the composer. So one question I have in mind, that when we are specifically touching this particular aspect of the moral duties and the rights, can we have, or is it possible to have the specific code of conduct or the ethical structure for producer, for composer, for performer, or anyone who is instrumental or who is the part of that particular legal structure? Like the other professions, like the medical profession has some code of conduct, the other profession like CA, those are also having a specific code of conduct, or the legal profession that is practicing in the court of law, they are also having their code of conduct or ethical framework. So is it possible to frame all of these things in a specific framework?
For me, I think the law itself is there. The copyright law is there. I mean, if you can't follow that, then you're not going to follow any additional rules.
Yeah. Okay.
Yeah.
Yes.
For that, traditionally there are some norms, like when you present a composition while playing solo tabla, then you just announce with touching your earlobe,
Yeah.
like ye Amir Khan saab ki bandish hai. So that kind of norm was always followed. Now, actually, many people don't follow that, but usually जो ट्रेडिशनल तालीम है उसमें तो ये बताया जाता है कि जब आप कोई स्पेसिफिक राग या बंदिश गा रहे हैं जिसका क्रेडिट आपको ट्रेडिशन से पता होता है
हाँ, नाम
कि
ही
भाई
है.
ये राग Sheno has raised his hand. Is there any question, Abhijit?
If he's
Okay.
raised both hands, then he is not happy. If he's raised one hand, then he has a question.
Yeah. Abhijit is there. Yeah, you can ask the question.
Namaste, ma'am. My question is with regard to the work on _records.com. And this is one point which I've been in conversation with even Sudhir Naik ma'am, whenever we have met in Bangalore, that my Gurujis have left a huge repertoire of old books with me, most of which are also out of print. So what are the permissions required, or what are the legalities with regard to republishing or digitization of these books for everyone's benefit, of course, not for monetary gains?
So this would again, I mean, these are technically, if you're reproducing it as is, so it's like making a copy of an original work. So it would also depend on the rights holder, like who's around right now. Like, you know, if the author is still alive, then you have a direct, if you have a direct channel of communication, you reach out to the author to get permission and perhaps enter into some kind of a royalty arrangement, saying that, you know, because I'm assuming this will be sold, these books will be sold, and that is what it is being, you know, reproduced for. So, and if the author is no longer there, then, and if it's still within that 60 year period, then the family is the one that you need to take permission from, and that's usually the title chain. And I think that, and being, of course, being credited as the original author is very, very important, because that's the most basic right.
Yeah, in this aspect, I can add a little. Like, there are many online platforms, or even some pages, like on Facebook, there is a page about publications on Indian classical music. So a lot of people actually exchange printed books, and which are copyrighted actually, or they are still available in market for purchasing, but they just make a PDF of that and exchange. Now here is a problem. You cannot do in this way. You need to actually purchase the book, but not just exchange. This is illegal exchange. But unfortunately, this is done, and we cannot. Actually, Sandhya ji can guide us what steps we can take to stop this kind of exchange.
Actually, the code of conduct is for the users.
Yeah. More than anything else. Yeah.
Indeed, that should be framed for users.
Unfortunately, the users, particularly for traditional users, is a slightly crass term, but the listeners, so-called music lovers,
Consumers. Yeah.
they they love music if it is free. The moment you start selling the music, the critiquing of the music starts
Yes,
from
yes.
there.
Yeah.
Oh, it's okay, but too commercial. Oh, this rag has this shruti and this and that shruti. You give it
Yes, yes.
free, he will be very happy.
Yeah,
So I'm just making a joke of it, but it
yeah,
is true.
yes,
And
yes.
the same applies to music books. Nobody wants to buy. We are running a record label and we have a large print section. I can tell you that ardent music lovers and musicians have been the last to buy products from it's not only about the record label, the distribution platform we are, but this is the case with many other platforms too. Unfortunate.
True.
Also,
Unfortunate.
about
That's true.
acknowledgement, I think, with things like YouTube, which has really opened a huge treasure house also of material which can be referred to. I think we also need, as teachers also and as people who are learning also, we need to now start accepting that we have sourced some material from these platforms. I think I come across a lot of artists who are singing material which they could not have learnt directly. They have learnt it from a recording which has been made available on YouTube. But we need to first of all ourselves say that I did not receive this in Sina Basina Talim from my guru. I found this recording and I referred to it and I'm singing it today. I don't think it makes us lesser artists or human beings to acknowledge this. If that platform is a valid platform which we are actually grateful to for also providing all this material, we should encourage students to say so, but not acknowledging where they have learnt it from and from which. I think, issues of not being loyal to your teacher or not being loyal to your gharana, etc., come up, which now need to be demolished. If you have learnt it from YouTube, please say YouTube is my guru for this, and the YouTube recording of so and so is my guru for this, and accept it. If it is a good performance, there are very talented people who are singing all this material but saying traditional. What is traditional? We know that this is not traditional. We know the source, as
Yes.
students ourselves. I mean, I'll give you an example of one composition which is popular across all kinds of vocalists. Rangi Sari Gulabi Chunariya, as sung by Shobha Gurtuji.
Yeah.
Everybody's singing it, playing it. They could not have learned because many of them are so young that they could not have possibly learned from Shobhatai. They have learned from a recording, possibly on YouTube or otherwise. Why not say that you learned it from a recording? Why not say that those, because then it becomes a gharana issue. I'm the torchbearer so and so gharana. How can I say that I learned from another gharana? So I think in the world of classical music also, we have to start acknowledging that we learnt this not from a person from in front of whom we sat and learnt with reverence. We took it off a recording and learnt it. This is what, if archiving is important, use of archives is also important.
Yes.
I think we need to acknowledge that.
Yeah, that's very important. One more thing that should be taken on this particular discussion, that now it is the era of remix music again. Can you throw some light on the originality of the content and the overall, whatever the compositions we are being bombarded, the remix part of that? Sandhya ji, Shubha ji, Aneesh ji, Chaitanya sir.
I'm laughing because I mean this is like a this is a favorite topic of mine to vent
Yeah.
about. I mean, I just it's and I think the ownership of the songs has a huge part to play. Like, so I'm talking about the film industry specifically, where you have seen like a spate of remakes that have come from music that has come out in the 90s, and they're all more often than not owned by one or two large labels. So when the labels own all the rights to a particular song, having it remade is very, very easy because they just need to hire a producer to kind of rehash it, add a few beats, and then release it. And it's anyway riding on the popularity of it, of what it had from the 90s. And it kind of like takes it basically like, repackaging it for the younger generation kind of situation. But the problem with that is the original composer kind of gets completely eliminated from the picture because the new version is going to get that many more hits. There's that much more revenue that is being generated. But given that the composer would have signed away all of his rights back in the day, he's not going to be entitled to anything going forward, because even with the new remake. And that, I think, is the problem that we are facing today. And there's like, obviously I'm not going to go into the whole discussion about the lack of originality and why are we like rehashing, why can't you just come up with your own new original music and make it as peppy and
Yeah.
catchy. But that's a topic for another day.
Yeah. And the same thing actually, not only with film music, this is happening also with classical compositions because of the fusion era that we are living in. Everybody wants to do fusion music, which is perfectly fine, I mean, I've been involved in intercultural experiments too. Now, how much weightage to give to original material there, and how much do you want to rely on pre-existing, and how much is the pre-existing material actually fueling whatever you're putting out there is important. And there are when it comes to vocal music, for instance, vocalists as part of an ensemble, very often they will either take traditional material like chap tilak or whatever, from the Pabali kind of repertoire, or they will take even classical bandishes. I remember one, there was a Jinjoti composition of Ratanjan Karji, Savare, that one, yes. So, and nowhere in the publication of that was it mentioned that the vocal composition is by Dr. Ratanjan Karji. Everything else was written, the names of the musicians, the name of the composer of that remakes and everything, or the fusion track was given. But the original composer of that bandish was not given. And similarly, now you are having bandishes of Chayanat or Jajavanti or whatever, being arranged with a full ensemble and choir and everything. It's wonderful. You can do whatever you want, but at least acknowledge who the original composer was.
I think some hands are raised. Kedar,
Yes.
Nidhi Gandhi.
Who have raised a
Yeah.
hand?
Yeah, there are
Kedar,
two raised hand, Kedar Deshmukh and Vidhi Gandhi.
Hi.
Yes.
Pranam Aneesh ji, Pranam Shubha ji. So I have two questions. First is related to the concert which used to happen in Pune, that is Baja Gaja. So why that has been stopped? Because we have beautiful memories for that concert. So the first question directly related to that. And the second question, so as we talk about the code of conduct for artist and performer, so do we also think on the part wherein the code of conduct should be made or created for the volunteers as well?
volunteers.
Yes.
Okay, so to answer your first question, actually, it's not part of the seminar. So
Yeah.
I'll just do it in one line that there was no financial support for that. Simple. Everybody understands that. Second is I didn't understand which volunteers and code of conduct. Which volunteers?
Yeah. So we talk about so there are rules and regulations to be followed by a performer or the listener, but do we also think and maybe it's a thought process wherein we also frame or design some code of conducts for the volunteers in order to ensure that the event is successful, or we
Acha.
yeah.
Okay.
Yeah.
Shubha, you want to go for that?
Well, I guess the person who's managing the event will
Yeah.
have to brief the volunteers, because volunteers, when they come, they're actually trying to help you, and so you have to tell them what is the code of conduct that they have to follow. For example, I find that a lot of people who want to help out will keep their phones on because they possibly have to communicate not just with the artists and with the organizers, but also perhaps have other, they won't even switch off their telephones. Now, just this is simple concert etiquette that people who come to listen need to have their phones off and don't need to be looking at their phones all the while. It's distracting for the artist to have a audience full of people doing something on their phones. I mean, even if it's tweeting about the concert, but if it happens all the time, I think that's something we should avoid, perhaps. So yeah, Anish, go ahead.
Yeah, I was just going to add to that. Very often you have tickets being sold, or passes to a concert being printed, and on the reverse, you have certain disclaimers.
Mhm.
And one of that is that you may be photographed or filmed um, as part of this concert, and by buying this pass or ticket, you are agreeing to being photographed. Okay, isn't it strange that you put that out there, but you don't ask performers for their permission to record their concert?
Yeah. Uh,
Yeah.
to Kedar's question, I can add that in my last day's presentation, I mentioned about the 5 dharma: Gayak Vadak dharma, then Sabhapati dharma, Samaj dharma, Yajamana dharma, and Karyadarshi dharma. So you are addressing to that Karyadarshi dharma, where the organizer is expected to take care of proper arrangement of the concert or the event with artist items and all that thing. So addressing the volunteers or training them to behave in a particular way was part of that dharma. Unfortunately, we don't find that today largely, but I can give one or two examples. Like when I was in college and I was like grooming as an artist, I also used to work as volunteer for many organizations in Pune, and few of the organizers were so keen about instructing the volunteers, like what to wear, how to पेश आना, कलाकारों से पेश किस तरह से आना चाहिए, किस तरह से उनके वाद्य उठाना चाहिए, या ग्रीन रूम में किस तरह से आपको बर्ताव करना चाहिए, तो बताते थे कि क्या क्या कोड ऑफ कंडक्ट है. So in that era, I think the organizers were very sensible in that regard. Today, I find very less organizers who are sensible in this regard. But I can give one example of Vasantotsav in Pune, where there is a large crew of volunteers and there is a head of that crew, and they give very good instructions to these volunteers, and I found the volunteers very well behaving. They don't use the mobiles, or they don't have the program on like live Facebook or anything. ये बकवास वहां नहीं होता. तो I think that is a good example.
एक लेकिन इसमें ऐड करूंगा कि sometimes event managers give in-depth instructions to their interns who are working with them. Those black t-shirts and everything. So very immaculate instructions: do this, do that, everything. But contracts with artists are not in place. Not in place. Event managers stroke curators, they don't want to address the issue of the actual contracts. Okay, other stuff, there should be marigold here, there should be white chadar and this and that, and if they touch the feet of the musicians when they enter, all those things are, and which organization I'm referring to also. So, but we need to be careful, and until the musicians don't raise their voices, nothing can happen.
Yeah, sure. One more question is that there is the huge difference between the Indian music industry and that of the Western music. So while there are some big music labels, they let the artist to own all the rights of their music if they are the original owners. So why such choices are not given to the artist while the big labels continue to exploit the artistic work? Again, Sandhya has
Yeah, I
a
can, I
smile on
can,
her
I
face.
can answer this. But again, I think there's no, I don't think there's any right answer to that, to be honest, because
Okay.
it all depends on the popularity of the artist as well. No, if you, we can't really compare the Western industry and the Indian industry except in terms of how distribution works, because that's pretty much global now. But how the industry works is very, very different, because like I said, we are very unique that way. We have the film industry, we have the classical community, we have the independent music community, and all of them have very different dynamics and very different bargaining tactics as well. So that I don't like using that phrase, but it is at the end of the day a power play. So whoever has more money, whoever has more popularity has a better bargaining power. And that is has been leveraged over a period of time. So if you are an upcoming artist, your ability to negotiate something like that is going to be that much harder versus someone who's well established and been in the industry for a very long time and is very popular. But I know for a fact that even a name like A.R. Rahman has had issues with labels because he has, negotiated for his rights. And I think everyone who's on the panel have themselves gone through, issues when it has been about negotiating with a corporate, because you're not, for them it's about, it comes down to numbers for them. So there is no, I don't think there is any way to fix that apart from a mindset change.
Uh, Pratik, can you put the questions which are actually sent us to?
Yes, I'm putting those questions
yeah,
only.
yeah.
Yeah.
Because there are
So-
some raised hands, but we can actually address them later on. We will first take the questions which were emailed to us earlier.
Yes. Sure. One more question is from the audience that we have got, that can the copyright be asked for the musical notes from the music sheets for the melody of a specific song?
I didn't understand that.
I didn't understand that.
Can copyright be, so say the question which I got, I read it as it is.
From notation.
Yeah, it may be about the notations, maybe about the notations or a specific part of a song. And for that part, can we get the copyright or something like that? So as because you were talking, Aneesh ji, you were talking about the Padhans in
So notation can be copyrighted, and it has been copyrighted. And there's a fantastic example of Western music which has been copyrighted. So it can be done here as well.
No, Anish, notation can only be of a composition.
Yeah.
And if you want to submit the notation as one way of registering copyright, then yes, it can be used.
Yeah.
But otherwise, notation in itself has to be of a composition. So notation itself cannot be.
No, not notation, not saregama, but it has to be a composition.
Yeah.
But I think that's what they mean.
I don't know how it was put across. Can notation be copyrighted? No, but notation of a composition.
Of a composition, yeah. So
I will give you an example. I will give you an example of tabla. So Chaitanya, you will find this very interesting. I composed a composition. I have the date when I composed it, and I performed it on radio also. I'll have to dig out my radio recordings to see which day. Subsequently, the same composition, but it begins with dhin in my case. That person did dha. And it from then on, it is called his composition.
Oh.
Just making a small change of
So now who's going to battle it out,
Yeah.
So I stopped playing that composition, It's okay, because it left a bad taste in my mouth.
Yeah.
So these are unfortunate things that you can't battle out, But hopefully you have some creativity left in you to go along some other path.
Yes.
Yeah. So one more question which we have got from the participants, that in various temples, we find many bhajans, those are played in the tune of some of the film songs. Okay. So does that violate any copyright law? And what thing we can or throw some light on that particular part?
So it does, because it's basically reproducing the composition, changing the lyrics. So it's a derivative work of the original composition. So I think, I'm not going to take names, but there is a very, very large record label that started its business like that.
Yes.
Taking, and now obviously is in the center of a lot of copyright infringement claims on the other side. So it's just the irony behind it. But that is also copyright infringement. And given that those bhajans are then packaged and then sold, there is monetizing as well. So it's not just a reproduction which is then played publicly, but it's also sold. So there is, if the original rights holder needed to take, file a claim, there is a cause for action over there.
We'll mention the name after having some tea.
No, but interestingly, I just want to point out that in the Hindustani tradition, there is the tradition of having a joda, which is an answer to a previously existing composition. So if you really admire a bandish and you want to make a matching pair, which very often means that you change the lyrics. Here it's actually technically very similar to what we were discussing, but it exists, this tradition exists in Hindustani classical music, where it is acknowledged that you are making a joda. So by acknowledging that the original work is the previous one on which you make the derivative work, there is an acknowledgement of the original work. Of course, there is no legal discussion on this, but here's an interesting example of how a version is being made and the original composition is being acknowledged, but this is all in the protocol that is observed. It is not a legally mandated thing, but this is how it was done and is still done in Hindustani classical music.
Absolutely. Yeah. There are many compositions from Banaras Gharana, like Rajan Sajanji used to sing. And I find that, this composition is very similar to some other composition. So I asked once him, तो उन्होंने ये कहा था कि हमारे परंपरा में बहुत सारे ऐसे जोड़ बने हैं बंदिशों के, कि जब उनको पुराने लोगों को ऐसा लगा कि अरे इसकी पोएट्री अच्छी नहीं है या उसका ताल का कुछ चलन अच्छा और होना चाहिए, तो उन्होंने पुराने बंदिशों के जोड़े बनाए. एंड ऑफ कोर्स उनको पहली ओरिजिनल बंदिश भी बताते हैं, सिखाते हैं और जोड़ा भी. तो that is, I think, a fair practice.
And I think Ranjani has pointed out also that Chaiti is also, the song form called Chaiti also uses templates on which different lyrics are then imposed. I think that's a good observation, because here technically you're making a version, but this is part of the tradition, and that's why I feel it's important to have these discussions about traditional music as separate from, let's say, the song format that we discussed legally.
There is a question by Brahmi. What is it? The surname I don't know.
Chandrasekharan.
Yeah. So he has asked that how can a rag be copyrighted, because it's just a melodic structure or a melodic scale, which is further going to be elaborated or explored. So how you can answer this question? Like, can such a melodic scale along with its rules and guidelines for interpretation be copyrighted?
Meaning, is he saying should it be, or what is the process?
Can it be?
No, he asking it like यह नहीं हो सकता क्योंकि
should it be? That is
Yeah, you can't, because I think, and if I'm not correct me if I'm wrong, but most of them are also in public domain. It's just how it's the expression of that rag in your unique style which you would like to copyright, that there is some copyrightability, if that's a word, that exists in that version maybe.
I
But
think there's some
not
area for discussion because very often new rags are being made by either blending more than one rag, but adding a certain component which becomes unique to that one particular rag. It therefore requires a different personality, a different swabhav, the rules that apply to it, the shastra that applies to it is not that of a scale. So in a scale, there is a certain, you can do what you like in the scale, but in a rag, there are certain rules to be adhered to. That's why the discipline of adhering to those rules makes it a rag and not a scale. So I think there is some room for discussion, but I don't know how it could be done because if you're using previously existed rags blended into a new combination, then is the new combination going to be copyrighted or not? Because it's in a sense, it's not a truly original work. It's a original blend at best.
that would still be a derivative work if I'm
Yeah.
not.
No. But just like when you add some a process or some kind of change in a instrument, and then you can take the patent, like it's your version of that instrument or process. Similarly, why cannot such kind of new creation of a rag with blending?
Can do it.
Previous?
Of course, you can do it.
Yeah, you can do that.
Yeah, I guess you can, but I think again, academically, I feel it requires some discussion about how original it is,
Yes.
And also that it is as Sandhya ji pointed out, a derivative work. If it is bringing together elements of previously existing rags.
No, but supposing you take, for instance, Jog Kaus.
Yes.
But Jog was already there.
Yes.
Yeah.
And the Kaus element is there. Or Chandranandan, for instance.
Yes.
You know, so many of those elements were already from existing rags.
Yes.
But it's a new picture altogether.
Yes.
You know that it is Chandranandan and it's not something else.
Absolutely, I agree with that. I'm only arguing on the on how it can be copyrighted and what you will say is whether or not it can be copyrighted. I mean, in general, we acknowledge that it was that this is the person who created this blend, but whether or not it can be copyrighted is another issue.
Yeah. That
The one more the point that may be added that as rightly pointed out by Shubhaji, that it is the original blend. Okay, so we are so even if that is the blend, if it is the combination of two ragas, one raga has some different Padi Samadhi, another raga has some different Padi Samadhi, but that original blend which is coming out of the combination of both of these ragas, that blend also has some different Vadi Samadhi and different kind of a mood and the color. So that's why I think that is the originality of that creation.
Yes.
In the same sense, actually, किसी ने पूछा है कि जैसे कि रविंद्र संगीत में बहुत सारी रचनाएं हैं जो कि पारंपरिक बंदिशें हो या बाउल गीति हो, अलग-अलग सोर्सेस से उन्होंने बनाई. तो यहाँ इसको हम कैसे देख सकते हैं? Even like we are not talking about film songs or recorded songs, but like such creations. Even in Natya Sangeet, there are hundreds of Natya Padas which were originally a bandish or some other kind of song. So this cannot
be derivative, na?
Yeah, it's a derivative. Yeah.
Yes. One more thing is there. Yes, Brahmi ji, you have one question.
So I'd already asked, am I audible? Sorry.
Yes.
So just wanted to add to this because this was essentially my research area during my master's, the impact of copyright in terms of Indian classical music and its artists. So this was the ragas and, the copyrightability of it itself was what I tried to deal with as much, but at the point in time, I did not have as much resources. my thought process is the fact that the melodic scale, like everybody has been like iterating it several times, because the melodic scale basically comprises of an arrangement of notes, cannot in itself be copyrighted. However, what I would also probably like to open up a discussion is that, like Shubhaji just mentioned, a raga is a lot more than that melodic scale. It comes with its own rules and regulations, what an artist must adhere to when interpreting it. So if we are looking at copywriting the raga per se, then probably detailing it out and recording it is something that probably can be explored in terms of copyrightability, because that interpretation is the uniqueness of that raga rather than the arrangement of notes in itself. Like just an example, like I don't know if this would be a very apt example, is that so we do this in broadcasting, right? There are these format shows that we see, Saregama and Superstar and all of them. If you look at it, it's essentially the same show. It's a music competition, but a lot of the times the format of it is copyrighted, right? And how they use it is. This is something that I've been like wanting to discuss in detail and like see an area where, a discussion forum, but this is just the thought I wanted to put across. And apart from this, one more point was, I'm not sure if this was again dealt with, because in between I had to be on and off. One is when it comes to regulating this whole, event space, when it comes to Indian classical music itself, or even the recording part of it. I've had a lot of my own friends. I also have been learning Hindustani music for, like, I also used to perform. I've had a lot of my own friends who are full-time musicians who are very reluctant to even, engage in a conversation when it comes to protecting their own rights. They're just very scared. And I've also had these discussions with a lot of established artists. They find it very, the minute I bring a business angle to it, they are taken a step back. I mean, I know the purity of music. Every form of music is pure, but yeah, this is something that I find in artists as well. It would be really wonderful if all artists came together, because I think as in classical music, this is one thing that I feel is a bit difficult to deal with.
Yeah, we agree with you.
Because I see a lot of independent musicians who are very willing. Like I've been part of a lot of discussions that Sandhya has hosted on Clubhouse and everything. A lot of these independent artists are, they're so up and about to even form societies if needed to kind of help themselves out. But I see that lacking with Indian classical musicians. There's so much more that even we can offer. But if this discussion panel can open up that in a larger way, I'd definitely be happy to be a part.
Having said that, and this is not to deride what you term as independent artists, actually all of us artists are independent, so that's one thing. But normally when we talk about rock bands, etc., then we think of them as independent artists. Having said that, they also draw a lot from existing material. So while they are open to such discussions, very often they are not too open to such discussions about their own work when they are drawing on such material. So we have to think about that as well. Secondly, the part about rag, I think the definition of the rag itself is to do with not just a sequential arrangement of notes, but a mood, a character, specific mood and character that rag evokes.
It's a profound bringing together of, it's not a melodic sequence alone.
Forget about the philosophy of it. I'm just saying in pure practical terms, it is a particular mood and identity that is created. So therefore, in the past, very often gharanedar musicians never taught necessarily aro avro. Yeah, they taught chalan, because so and रागवाचक पलटे होते थे उसमें जो दिखाता था कि ये मूड ऑफ द राग ऐसा है, कैरेक्टर ऑफ द राग ऐसा है. So I think we are very often bogged down by the music school kind of thinking of what a rag is. And that's why we constantly refer to it as a sequential arrangement of notes, which it actually is just one part of it.
Anish, there's one thing that it is possible for two or more musicians at different times in history also chronologically to think of similar blends and call them by different names, because they may, I mean, I may not know, for example, that Chaitanya ji has thought of a blend between two rags, which I am also considering. And it is possible, therefore, to have some kind of ambiguity. And we know that this exists in the Hindustani system also. So I think these also need to be considered. And then we need to say that these are similar blends. This is Chaitanya ji's version of it. This is interpretation of it. This is my version of it. I think that is the only way to deal with that kind of, overlap.
Yeah, very correctly said. Like there are many stories about creation of Rag Chandrakans or Madhuvanti, and there are various versions, and various people were credited for creation of these ragas.
Yeah.
Okay, I can give a recent example. Like there is a rag called Madhurkans, which is credited to Dr. Prabhatre. I didn't knew that. I never heard it from her or any other musician, and I just came up with that rag, similar rag. I can say the similar notes, but the perception of the rag is totally different. And I named it as Vyokans. But when I got to know that, oh, this scale is used by Prabhatreji earlier, then I just gave her credit, and I mentioned in my book that this is rendered by Dr. Prabhatre with name Madhurkans, but my interpretation of these notes or the structure is different. So I am naming it as my composition of the rag Vyokans. So this can be done. Like you can give the credit and go further.
Yeah,
that is very appreciable. I think there should be a separate session for all of these people from the Kunte sir, that what ethics should be followed while doing some compositions and all those things.
There is Renu Sirothia who is raising the hand for a long time. So
yeah. Renu ji, you can go ahead with your question. Renu ji?
Or Pratik, you can go ahead with other questions.
I think Abhijit Shenoy ji, he has also raised his hand.
Actually, we have answered his question. So
okay, fine.
I have one more question.
Okay.
If time is permitting. And since I come from a value education background, which I'm teaching at a university, and this may sound very, very philosophical right now, but I would love inputs on this. That given the COVID lockdown and sometimes, we have seen a lot of artists pass away due to COVID reasons and other fatalities. Is it better to share everything without worrying about the copyrights? So may seem very ideological or philosophical. The panelists' take on this.
No, share what? Meaning, I didn't understand.
Bandishes, compositions, books, etc.
No, but what has that got to do with lockdown and COVID?
I think it's better to put everything out there rather than being posthumously remembered for it, or a loss of that knowledge.
You're talking about current composers?
Anything for that matter.
No, like let's say, so if you've composed something and you choose to put it out there free of cost, it's perfectly, I mean, it's your decision because you're the composer, but we can't decide for other composers.
Yeah. In the same way that we can't, let's say, tangible property, can we make all dwellings now free for everyone? Share it with everybody. That would lead to an anarchic sort of a situation also.
This is a problem actually which occurs very often in private collections of recordings. Many, they appear private collectors once upon a time, they have recorded this material, not all of them, some of them have recorded without due permission and just plonk the mics right in front of the artist. And before you know it, you've been recorded, and few years down the line, they have reached various places. And now suddenly they have become very altruistic, and they put it out there on YouTube, because for the posterity of humankind or whatever, we are making all this available. And the only credit there is that me, as a private collector, I have put out this material. Other than that, there is no due credit given. So this, I feel, is wrong, absolutely wrong, unethical and illegal.
I guess if you own, let's say you have a book in your collection and you want, and a friend asks you for it, you give it to that person and you share it with that person, thinking that they'll read it and give it back to you. In case they don't, then I don't know what you would feel, but if it's a prized book in my collection, I would be very upset at not having got back a book which now is not available, not in print. I think sharing has to come, with a kind of an understanding of what is going to happen further. I understand where you're coming from and I appreciate that. But what is not mine, how can I share it with everybody?
Right.
So I think the person who wrote that book, who published it, we are obviously governed by those laws. And we can't suddenly say that, okay, now let's share everything because life is short and what are we sitting on all this material for? Yes, but I think then it would become very anarchic and very difficult to deal with, because when sharing happens, as I said, even in the small matter of a wonderful book that you have loved, and I love books, so I would not want to just lose books, even if I'm happy to share. But if it never comes back to me, then what was the point in giving it away? I think it has to be done with a sense of purpose and also the sense of understanding of how much and what you can share.
Yeah. So Ranjani Ramchandranji has raised hand. So please go ahead with your question, Ranjani.
Yeah. Hello.
Hello.
Hello, Aneesh ji and Shubha ji, Chaitanya, and it's lovely. It's really lovely to see all of you, and I hope we can meet
Yes.
non-virtually at some point. So I agree with so many things that you said actually, and in fact, I would like to share that the River Raga concert of SAF, the Serendipity Festival, was probably, to my memory, one of the most detailed contracts that I signed for a concert, but I don't remember we actually signing such things for any of. Yeah. So this question is, I don't know who it's directed to, maybe Sandhya ji, and or you can also give your inputs. There are these YouTube, when we upload concerts on YouTube, suddenly you find ads. I have no control over this. So who is making money? YouTube is making money, but who is YouTube? One is that. The second part is, an organization invites me for a performance. They record the performance, and their YouTube channel is like a very, very prestigious YouTube channel. And so they have my performances there. And then after some time, suddenly again, I find a lot of ads generated. And so in that case, is it not important to, again, that contract thing becomes very essential? And who is making money? Is the organization making money on my behalf, my and my co-artist's behalf, or how does this work? I just wanted to.
Typically, when you're uploading something onto YouTube, it allows you to monetize your videos. So whoever owns the channel, if you're seeing ads on that video, then technically that channel owner is earning money off those videos through monetizing it. That's how YouTube has, basically YouTube has acts as an inventory for space where you have brands which will keep publishing ads. Now the catch over here is that there are certain instances where even though you are not monetizing your video, which is on YouTube, someone else is monetizing it, because the content on that is something which is connected with that person who's monetizing on your channel. So YouTube has relationships, large contracts with labels, with aggregators who kind of control the content that is being shown on YouTube. So if you have concerts which have songs that, I know this might be a little alarming when I'm saying this, but if you're performing songs which are from the catalog of a certain label which owns those songs, then the label can monetize the songs being performed on someone else's channel as well. And they have those agreements with YouTube. It's very, very unfair. And
Yeah,
there's
but
nothing
then this is a
regulating it right now.
performance which I performed and I am uploading it. Like, I
Yeah.
mean, it's not a song.
It's not a song.
It's like
Yeah.
a 50-minute performance
Exactly.
of one single rag. So
why my question to you is, if it's on your own channel and if you haven't monetized it, then I'm not entirely clear on how they're placing those ads there. Someone else is basically, using your space as inventory to show their ads and earning money off it. Who exactly it is not something that you or I can figure out. It's something that only YouTube would have access to. But if it's on your organizer's channel, so ideally, typically speaking, the owner of the channel is the one who can monetize and make money off it. If you have chosen not to monetize it on your own, then someone else can use the space on your YouTube channel to monetize. That is the arrangement that YouTube has.
okay, so that's where then the organizers don't have any sort of agreement. I mean, they just organize the concert and then say, okay, bye.
Yeah.
Then
Which
they
is really,
sort of
I
upload.
hear your point, because they are technically making money off the recording of your performance, and you're not really getting paid anything off it. And this is where your performers' rights comes in. And this is what Shubhaji was also mentioning earlier.
I mean, even not making money off it,
yeah,
permission to put it, first of all, to record it if you haven't given them the permission, and further to disseminate even on a non-commercial basis if you haven't given that permission. But I think you wanted to say something about video uploads, right?
No.
Oh, okay. And also in YouTube, I think you need certain number of hits or something. Only after that, I think 1,000 or something like some.
Yeah, subscribers. I think you need to have X number of subscribers to be able to monetize.
Yeah.
It keeps changing. It's like it has to be the most complex mechanism I've ever come across.
No, that is for your own channel. But then when I'm talking about an organization which has, they have recorded this live concert and they upload, and in fact that organization's USP is their YouTube channel. So they have like tons
then
of
they'll definitely be able to monetize it. So
But
I'm assuming they have that
for
many
that.
subscribers.
But they don't take any kind of, there's no contract.
Consent,
with the artist, with
But
the
did
co-artist.
But did they even take verbal permission from you to record and upload?
Yes.
Then that is in a sense, I mean, it's a non-written, it's not a written contract, but they've
But then, like Aneesh ji pointed out, that it's high time. We also get. I don't know whether it's ever possible to have a musicians guild or anything, because so many things which, for example, Sandhya was talking about, and some of the things we are not even aware of. Which can become, sort of sorted if we have a common forum where it can be put forth and these kind of conversations can take place. So,
Ranjani, I think also if you are getting sort of thinking about this, then perhaps what one suggestion could be that even without any hostility, you could easily ask an organizer, now that you have been through this experience, that you had given a verbal permission to record, but you feel, why am I not being included in any monetizing or whatever, or even in, let's say, the quality of the recording. So if that is a case, then perhaps it is time that you were to ask that organizer or other organizers who come to you, do you have a contract? It's not wrong. I mean, there is no harm in asking. If they say they don't have a contract, do you want one? Maybe you can say yes. Maybe you can have a contract ready, which just states that these are my responsibilities, and that's still not a legal contract, but at least it is a statement of fact.
We have model contracts on _record, so you can download them if you like.
Okay.
Yeah. You can tailor them.
Yeah.
So
And one more
probably,
thing, no, just one more thing I wanted, this thing about Tagore songs we're talking, there are these derivative songs, but then the Tagore songs which are derived from original bandishes, should they be considered as derivative songs, or they are like original, they are the original copyright, not copyrighted now, but they are originally composed by Tagore himself, right? So is there a difference between whether they are supposed to be called derivative songs or they are original songs?
No, I can say like some compositions are exactly copy of a Bandish or a previous composition, and the poetry is of Tagore's. So that kind of compositions are derivative. But yes, of course, there are many compositions which were taken just inspiration from that composition, and the Tagore's composition sounds entirely different. In that case, we can state that such compositions as original compositions and not derivative.
I'd like to clarify actually. So the previous example that you gave, those would be covers. So if you're recreating something as is, without any like additional, there's no unique addition to it. There's no unique expression to it. So that would be a cover. And a derivative work is when you are actually creating a unique rendition of an existing composition or a rug. So
Okay.
that would be a derivative work as per law. I mean, copyright law.
Okay. Yeah.
And you have to be very careful whether you're talking about this in Bengal or elsewhere.
Yeah, exactly. Because whatever is being said, I don't think it would be agreeable, because it's like, I don't know.
I know.
Okay, I won't say more.
Yes, somebody.
we are, yes. Partho Dattaji has raised his hand. So probably this will be the last question.
Yeah.
I think Parthoji is muted.
Hello?
Yes, you're audible now.
No.
Parthoji?
No, he has is in mute mode.
I asked him to unmute, but I don't know what's the problem. Okay, so probably the last question from the student point of view, that may be how the law students can help the music students, and how the music students they can help the law students to understand the issues and the challenges which they face, and how both of these fields go hand in hand. So this will be the concluding remark by Shubhaji, Aneeshji, and Sandhyaji, probably by Kunte sir as well.
Well, it would be great if a workshop could be held for music students to make them aware, and perhaps that could be done by the law college. And similarly, perhaps a small introduction to various aspects of Hindustani classical music could be arranged by Lalit Kala Kendra for law students, and I think that exchange of information and knowledge would be a good thing to consider, and then work on to make it more permanent. Even an understanding of how the music works could be created, a course could be created for event management institutes as well. I think all of that will make it possible for the situation to become better. Aneesh has something to add also.
I know for sure that the music students will agree to perform for your law students forevermore. But whether law students, potential lawyers in future, whether they will defend the rights of the musicians, we shall see.
So I think Sandhya can answer this more particularly.
So, I mean, but I agree to both Shubhaji's and Aneesh sir's comments. I mean, I think in terms of, at least from what I've understood, a lot of lawyers themselves have not understood how the industry works, and so the advice also gets impacted as a result. And having that understanding has helped me so much, and it also helps that I'm married to a musician, so I work around with a community of artists as well. So it just, there is a personal aspect which I see, because I know that artists don't view their, it's not just a business for them, it's an expression of themselves, so they're viewing it very differently. And I think understanding that and figuring out, and when you're talking about enforcing a copyright, is almost as good as talking about an artist's own rights to protect themselves, because that the work is an expression of their art. And so I think setting context for a law student when they're approaching the subject of intellectual property in music specifically, if they're opting for a specialization in music, they should have like an introductory session on how the Indian music industry itself is, how it works, and how the impact of classical music on law, how the law should change to adapt to it. So these are all things which can be, I think, put into effect from the law school's perspective. And I think for artists, it's about simplifying it. Most people, I mean, the kind of information that I take for granted sounds like Greek to almost all the artists that I've worked with, because they don't understand a lot of the terms, and for me it comes very easily. So to simplify it and make it not as legalese and not as complicated, that is the responsibility of the lawyer. I don't believe in making things so complicated that you only have to come back to me. You should be able to defend yourself if I'm not around. That is the point of the lawyer client relationship. So I think that is important.
Very rightly pointed out. Yes.
Yeah,
Chaitanya.
I can say a few words in this regard. Like I heartily welcome all law students to our course, which is music appreciation course, which has started just this year, and they can join this course to get acquainted with music and the nuances of music in general and in Indian music in particular. And similarly, I can say that I can ask for lawyers or experts in law to have a sort of workshop for musicians to get acquainted with the law. So there can be a mutual exchange in this regard.
That is very welcoming suggestion which I got, because we have our intellectual property rights cell in our college, and many of the students, they have registered for that particular cell. So there can be the collaborative kind of the thing for creating the awareness among the artists and the performers. So that is very welcoming kind of a suggestion, and very rightly pointed out by Aneesh ji, Shubha ji, and Sandhya, that these particular things that should happen. As because I'm not purely from a legal background, and also I'm not purely from the Guru Shishya Parampara. I belong to both of these things, as because I'm also learning the Hindustani classical since a few years, and also I belong to the legal academia. So that's why this particular idea, I thought that is very important to be brought on the public platform to understand the nuances and understand some of the problems, the loopholes in the IP laws and the rights of the performance and all those things.
Yeah, I can also suggest one thing. Like in our university, we have a compulsory module for human rights and cyber securities. Like every student need to have that module. Similarly, I can propose that we can have such kind of module about copyright and intellectual property for students of performing art, like not just music but dance, theater, and music. So that can be a coursework module for every student to opt.
Sure. That is very welcoming suggestion again, and I accept your invitation, and surely we will work together for this innovative kind of a thing. And surely I assure you that whatever support, whatever I can say that up to my knowledge, whatever guidance I can give you about the law and the legal perspectives, I'm always open to share that particular knowledge with all of the music students. That is always the good thing. And lastly, to end up with the session and the 2-day national symposium, it would be our pleasure and we'll feel grateful if Shubhaji, you sing Just the 2 lines for all of us. Just 2 lines.
Hey, yeah. Come on.
Yes, absolutely. This time I will ask Aneesh to sing you, but this will be a unique, and I will play tabla or table as it is called very often when autotype is on.
Please, please.
What can I sing? सब मेल गुण की चर्चा कीजे. This is a composition by Azmat Hussain Khan Sahab, who wrote under the pen name of Dil Rang. So I'm acknowledging that this was his composition. It was taught to me by Pandit Jitendra Abhisheki, and it is in the rag Bhimpalas. सब मेल गुण की चर्चा कीजे, तासो बढ़े मान गुमान. सब मेल गुण की चर्चा कीजे, सब मेल गुण की चर्चा कीजे. गुण की चर्चा ही हम कर रहे हैं, इसलिए थैंक यू फॉर.
क्या बात है शुभा जी. So just as a concluding remark, I would like to request Dr. Kranti Deshmukh, principal of Marathwada Mitromandal Shankarrao Chavan Law College, to express a few words.
Thank you, Pratik. First time, because I, being the administrative head, generally cannot attend the entire session, but today, due to presence of Shubha ji, Aneesh Pradhan ji, Kunte sir, and Sandhya ma'am, I personally attended entire session. I was listening each and every point discussed during the session. What are the problems related to artists and how our law is responding to all these problems. So definitely we are actually a law school and we are teaching students. So I think means today's discussion, I can conclude that when we teach law, we should not just teach law, we should actually teach law with the problems. Because if we tell them the problems and if we teach them the law, then they will do the blend of that, and sometimes they may come up with good conclusion of this today's session. My heartfelt thanks to Shubha ji, Aneesh ji, Chaitanya sir, and Sandhya madam for their presence, for their active interaction and participation during the session. And today, actually, we are meeting virtually, but definitely we would like to see you in our campus. And definitely, sometimes if it is possible in future, we will have direct interaction with students and participants. Thank you so much.
Thank you.
Thank you.
Yeah, and that will be probably the musical interaction by Aneesh ji and Shubha ji with our students. And we always welcome both of you, and also Sandhya ji, Chaitanya sir on our campus in Pune. And at the last, as the part of the concluding remark, I extend my thanks to Lalit Kala Kendra Gurukul that they have accepted our collaboration and they have joined their hands with us. And it was very it was pleasure to join the hands with them and to discuss such the important aspects which are very much apt and which are very much required in today's era. So I would like to extend my warm gratitudes to Dr. Praveen Bole, HOD of Lalit Kala Kendra, and Dr. Chaitanya ji Kunte. And he has guided me a lot about arranging this particular symposium and what kind of the things we should take into account. Also, I would like to extend my warm regards to BG Zadhav sir, chairman of our institution, and Dr. Kranti Deshmukh ma'am, principal of our law college, Shankarrao Chavan Law College. I would like to extend my warm regards to Shubha ji, Aneesh ji. They have joined virtually to this particular discussion. Sandhya ji, Kunte sir as well, that he has guided on the historical approaches. Sandhya ji has rightly pointed out various legal aspects, and also the other speakers, that is Dr. Adam Dubin and Rajendra Vaishampayan, and they have also contributed their intellect in this particular symposium. And last but not least, all the participants, because without them, this particular event would not be a successful kind of a successful event. So I would like to thank all the participants to actively participating in this particular symposium. And with this, I extend again my warm
Pratik.
gratitude to all of the participants. And yes.
I'll just take half minute.
Yes.
I think Chaitanya Kunte sir from Lalit Kala Kendra, all other dignitaries who are present, all of us would like to thank you also, because you are the coordinator of this program. And I have seen since last 2 months, he has taken so much efforts for organizing this 2 days national symposium. Because the moment he put that idea before me, that can we have such kind of national symposium, I was little surprised, because can we have national symposium on law and music? But he convinced us, he put that idea before our management committee also, and he carried wonderful work since last so many days. He is busy with everything. So I think we all would like to congratulate you also, and we are very thankful to you for such arrangement. Thank you so much.
Yes. Okay. So again, so with this, we are ending up with this particular 2-day national symposium on law and music. Thank you. Thank you so much all. Namaste.
Thank you, everyone. Thank you.